Yeah.
May it please the court. I just wanted to finish off briefly ground 3 before moving on to grounds 4 and 5 today.
Yeah.
Now, it seems to us the second main argument which the defendants make is this, that the judge had to deal with the core pleaded issues in this case, which is whether EE and Vodafone had colluded, and particularly as pertains to the email we've been looking at, whether that reflected such collusion. In particular, Vodafone emphasises that it disputed that it had provided any information to EE and says the judge had to deal with that pleaded dispute. But with respect, we don't actually understand where that argument gets the defendant. The judge did need to deal with the core dispute, just like the judge in Al-Madeni needed to determine whether Mars was responsible for her injuries. But, as we submitted yesterday, it is not permissible for a judge, in reaching his conclusions on an important issue in the case, to rely on a new and uncanvassed and untested theory of the facts. The defendant's position appears to be that once there is a pleaded dispute which needs to be resolved, there are simply no constraints on the judge in resolving that dispute. He's free to base his conclusions on a completely uncanvassed version of the facts.
I mean, the way it goes is this, isn't it? The judge faced with the challenge from Vodafone that it came from them is in a situation where he can either accept the claimant's case and find that it did come from Vodafone, or he could I suppose have found, well, looking at the evidence as a whole, I don't think it necessarily came from Vodafone. I can't actually say where it came from.
Yeah.
What we can't do is to say, well, I actually think it's more likely to have come from somewhere else in circumstances where the somewhere else hasn't even been bruited by anybody at any stage, either in pleadings or in evidence.
That's precisely our submission, my Lord, and we say that is precisely the result which follows from the way in which the courts have treated issues like this in Al-Madeni and Ali and Dink. So, in our submission, having reached a conclusion on the email which was prima facie incriminating, the judge was not then permitted to exculpate the defendants based on a theory of the facts which they had not advanced, which had not been tested in evidence or submissions. And this meant, like the judge in Al-Madeni, he was compelled to reach a conclusion other than that which he would have reached, it seems, with the benefit, as he saw it, of his new theory. But in our adversarial system, that is what the law requires. Pausing there, on the basis that there was consultation between EE and Vodafone, then we say it must be a matter for the lower court to determine what the implications of that are. Plainly, what the lower court might do will be guided by what this court says in relation to the law as far as grounds 1 and 2 are concerned, in particular, Anic and causation. But insofar as there are findings of fact to be made about the causal effect of the consultation, that must be for a first instance court and not this court. And notably, in the judgment, the judge does not engage with the question whether, if he was wrong and there was consultation, whether the Anic presumption could be rebutted. He does, in his judgment, make some observations on the causal effect of the transmission of the information, but all of his observations are on the premise that the information came in August from Carphone Warehouse. And
the difficulty, sorry, to interrupt you if I'm taking you out of your course. One of the difficulties, as I see it, is this: if you're right, and if the bottom line, if I can put it that way, is that the judge should have found, or a judge, if it's going to be another judge, and find that there was collusion with Vodafone, that does potentially affect other conclusions the judge reached about other pieces of evidence, because like a lot of these sort of cases, it's really a jigsaw, isn't it? You know, there's bits here and bits there.
yes, ma'am.
You can never, it's extremely unlikely that if there was collusion, generally, it's going to be as it were, in the public domain.
Indeed.
So you're looking at bits of evidence, and of course, if you conclude this bit is collusion,
Yep.
that may affect your conclusion on other bits.
Entirely, my lord.
And at some stage, we're going to need some help about what is said as to what on earth we do in terms of sending the case back or sending the case to another judge or whatever.
Yes. I mean, one of the things I'm going to say is that it's difficult for me to say at this stage without knowing what the court says about the individual aspects of the judgment which are unsafe. But what I can say is that if the court takes guidance from what this court said in the Archangelski case, which has been cited, perhaps I should show that briefly to the court. Authorities, tab 22, page 1079. The Bank of St. Petersburg and Archangelski. And I was going to direct the court to...
Sorry, what's it? Tab 22?
It's Authorities tab 22.
This is Bank of St. Petersburg?
Yes, my lord.
Yeah, okay.
I'm struggling with the pronunciation of
Well, if you called it Bank of St. Petersburg...
Let's call it Bank of St. Petersburg.
we know what... We know
I may not struggle with that.
It's...
Yes, if we could look at what...
familiar territory.
Yes. So 104, insofar as I've said above, there should be no new evidence on...
So what page are we on?
It's 1079, my lord.
1079.
Yeah, paragraph 104.
Thank you very much.
Let's start at 103. According, I'd remit the matter back to a new judge to determine the issue of whether or not the respondents are liable under Article 1064. That's the Russian code for conspiracy. For the alleged dishonest conspiracy, there should be no need for further evidence of Russian law. The question of whether the appellants actually sustained harm will need to be determined again. That can only take place after, one, any new evidence of the issues arising from the auction sales and pledged assets, and the valuation of the assets and the respondents' motives for acquiring them has been heard, and the evaluation of and inference to be drawn from the judge's findings, any new findings have undertaken. And so far as I've said above that there should be no new evidence on particular issues, I would repeat that I would not want to tie the hands of the judge to whom this case is remitted. If that judge takes a different view, having heard the argument, he may do so. The crucial factor is that the new judge is unable to determine the remaining issues between the parties fairly, even at this late stage, and notwithstanding the checkered history of the case. If that necessitates new evidence on a particular area, so be it. So, obviously, depending on what aspects of the judgment this court finds unsafe, there will likely have to be a debate in front of any future trial judge as to the scope of any new evidence.
Yeah.
Now, the learned judge has made a whole range of findings, obviously none of which are yet, at this stage, for good reasons, challenged by the respondents. The respondents are very happy with the findings the judge has made. And I mean, I showed the court yesterday the judge's findings about, for example, how these MNOs, senior people in these MNOs, approached their internal compliance policies. Matters like that, those matters like that, may not have to be revisited in any retrial, and this court could well say that. But I am slightly struggling at this stage to say precisely what the scope of the retrial might be or must be, but I'm going to, in the course of developing my submissions on grounds 4 and 5, be showing the court other aspects of, as my Lord the Chancellor puts it, the jigsaw, and how the learned judge in this case, in our submission, failed to join the dots. Now, your Lordship is right. As far as the email of August is concerned, our case at trial was reflective of information which had passed at an earlier stage. Under ground 4, I'm going to show the court, unusually in a case like this, how it is, we say, information like that may have been passed. But your Lordship is absolutely right that if the court comes to the conclusion that the judge should not have done what he did, there will inevitably have to be further findings of fact which flow from that.
Yeah.
I'm not sure that's a terribly satisfactory answer, but it may be that the answer is not satisfactory, given that we are potentially in the unpalatable position of having to conduct a retrial.
Well, if you're right, I mean, there'll be all sorts of arguments on the other side as to why you're not right.
Yes.
Which we'll have to hear, and we'll have to make our minds up. But if at the end of the day we conclude that you're right on this ground, then, speaking for myself, I can't at the moment see what else there could be other than some form of retrial.
Yes.
Because this court can't decide this point.
No.
And we can't decide the impact of this point on other points.
No.
I mean, it may be that one would try to circumscribe the scope of any retrial, much as the Court of Appeal did back in St. Petersburg. And as you
Indeed.
may know, there was in fact a retrial, and I think the judgment is still awaited.
Yes.
It's a massive case that was retried by Mr Justice Roth.
Yes. What I was going to say on this particular point, if I could invite the court to, in this connection, look at paragraph 72 of our submissions, which in Core Bundle 1, tab 3, page 42. Paragraph 72.
72? No,
72. Claims for you allege that two crucial players on the EE side were Mr Milson and Mr Alera. On the 20th of March, at an EE Business Review meeting, Mr Milson explained that EE could not exit Phones for You because there were strong outside players who could do deals with Phones for You to replace EE. And Mr Alera made a similar comment. However, on the 7th of May 2014, after the Sheen-Hum communications, Messrs Milson and Alera were positing a different scenario, that EE and Vodafone would leave Phones for You simultaneously, and Phones for You, lacking the time to replace both of their volumes, would starve. Now, I'm going to come to the Sheen-Hum episode in the course of grounds 4 and 5, but that is an example of how, if the judge had found that there was consultation, the judge would have had to look at what those gentlemen were saying internally in May in a different way.
Well, he might have concluded that that was indicative of the receipt of confidential information.
Yes, which is what we submitted at trial.
Hence the change of heart, as it were.
Yes, which is what we submitted at trial.
Right.
Now, if I could invite the court to look at what the judge said in his judgment, at paragraph 606 to 608, which is found on pages 429 to 430. One sees that the judge said several things which are all based in our submission on the proposition that the information was conveyed in August by Carphone Warehouse. Now, he makes a number of points. One, the information was not very specific as to exactly when Vodafone would exit. Two, people in EE's financial modelling team continued to model a scenario which Phones for You didn't go bust for some time. Three, Mr. Eyre, the modeller, was surprised when he heard that Vodafone was exiting Phones for You. And four, there was no indication that the expectation of an imminent exit was conveyed to other board members ahead of their decision in late August to agree the Carphone exclusive contract. The judge in particular notes that the desk presented to the board in August ahead of EE's final approval didn't change the assumption from the previous iterations of the deck that Phones for You would not go bust right away, which in turn implied that Vodafone would not exit right away. But of course, it never was part of our case, nor did it have to be. The communication was made to EE's board in August. It simply doesn't follow. As I said in submissions yesterday, What we have to ask is, were there communications which resulted in EE and Vodafone operating under conditions of materially reduced uncertainty? There doesn't have to be any agreement in blood. If Mr. Milson and Mr. Lolera, or as we shall see, Mr. Sheen, had information as to the intentions of Vodafone, that would be enough. Now, very clearly, none of what is said by the learned judge in paragraphs 607, 606 to 608 is on the basis that there was collusion between EE and Vodafone. We've already seen what the judge said in 603 as to why he thinks Vodafone wouldn't have said anything in August. But our case is that the evidence showed that there had been collusive contact prior to that, and that was evidenced by the expectation expressed by Mr. Milson that Voda was about to pull out. And with that, my lords and my lady, I propose to move on to grounds 4 and 5.
Yeah.
I'm sorry, specifically that collusive contact was which one?
Forgive me, my lady.
Which, when you say it was earlier,
yes,
you rely on, is it a specific?
Yes,
it's the Sheen-Hum.
we specifically relied on the Sheen-Hum
yes,
communication.
And that's what, April?
That is in April, that was on April the 2nd, 2014.
Okay.
But does your case go beyond that? Or was that the specific?
Well, our case goes beyond that. What I've been trying to say is that in cases like this, the evidence often shows that there was a communication, and it's almost impossible to know how or when communication took place. In this case, we are fortunate in that we are able, we say, to demonstrate to the court that there was an anti-competitive contact between senior members of the EE undertaking, namely Mr. Sheen of Orange and Mr. Vodafone, Mr. Hum of Vodafone. Now, we say that the contact is evidenced in other ways, and I'm going to show you how there was a dramatic change in the assumptions underlying a modelling carried out by Mr. Eyre. But that is all, we say, evidence of a communication. We cannot be precise as to when there was a communication, other than to say, look at this communication between Sheen and Hum, which, as I will come to reiterate, was proposed to be continued by Bernafons. Now, if can we show a smoking gun in this case? It's very difficult in cases like this to show a smoking gun. But when we get to that particular episode, you'll find that there is a gun with at least a warm barrel, if I can put it that way. Can we then turn to grounds 4 and 5?
Okay.
And our submissions on the effect of the delay in producing this judgment. Grounds 4 and 5 are obviously interrelated. Ground 5 is a compartmentalisation complaint, and ground 4 is a complaint that the judge failed to have regard to material evidence. But may I begin with, I hope not teaching the court to suck eggs in relation to the effect of delay, which is dealt with in the NatWest and Bilter case.
Yes.
Now, first, a few submissions about the law before I turn to the facts. Now, NatWest and Bilter is at Authorities Bundle, Volume 6, and 26, page 1245. Decision of Mr. Justice Snowden, as he then was, back in 2021. Decision of this court, quorum, Lady Justice Aspin, Lady Justice Andrews, and Lord Justice Burst. And that was a case where judgment was delivered 19 months after closing argument.
Yeah.
A delay of a similar order to the present case.
Yeah.
The learned judge found that the defendants NatWest and Mercuria were liable for dishonest assistance because two of their employees had shut their eyes, the judge found, to an obvious VAT fraud in the carbon trading market perpetrated by the claimant companies, and they thereby dishonestly assisted the fraudulent trading. Now, the main complaint on appeal is when making his findings of dishonesty, the learned judge had failed to refer to what was said to be documents or evidence pointing in the opposite direction or corroborating the trader's evidence. He didn't address submissions made about that evidence. And the Court of Appeal ordered a retrial because although the material the judge did not refer to did not show that his findings were plainly wrong, the Court of Appeal could not rule out the risk that the material could have made a difference to the learned judge's conclusions. And I'm going to come to the precise nature of that test in a moment, but it clearly differs considerably and very significantly from the ordinary appellate approach to findings of fact. So the first question is, what judgments does this NatWest standard of review apply to? Surprisingly, some of the defendants before this court appear to argue that the 15-month delay is not sufficient to engage that test. We've dealt with that in paragraphs 51 to 57 of our supplemental submissions and don't propose to go over the same ground in detail now, but there are two key points. First, 15 months is well over any relevant threshold. The guidance is to give judgment, however complex the case, within 3 months. And as we note at paragraph 95 of our first skeleton, judgments have been treated as severely delayed when the delay was 5 or 8 months. Going slightly over 3 months might not trigger the application of the test or be regarded as a tripwire, but in our submission, 15 months is not slightly over. The second point is that the reasons for the delay do not matter. What matters is the fact of delay, not whether there are factors which might explain it. And that's apparent from the authorities we referred to in our supplemental skeleton. So we say that the 15-month delay in this case between the closing of argument at trial and the production of the judgment in November 23, 15 months later, is comfortably within the period which qualifies for a review of the nature set out in the NatWest and Bilton case. So, what is the content of that case, or what is the approach that the court should adopt in that connection? There are points in the defendants' submissions which seem to give the impression that they are really seeking to say the NatWest approach is wrong, but that is not an argument in our submission which is available to them in this court. And it makes all the more important to be clear about what NatWest says. And your lordships and your ladies.
But I mean, what's said, I think, as I understand it, is that the judge says that the reason why it's taken so long is because he reread everything, and therefore it said, well, he reread everything, and therefore that's it demonstrates how diligent he was. And he is a very diligent judge in this judgment, and indeed in all his other work.
Yes.
But that doesn't really answer the point, does it?
No, my lord, it doesn't. As you'll see from the...
You can't possibly spend 15 months rereading everything. You might. I mean, it certainly explains why it took longer than 3 months. And I mean, any judge faced with this sort of case, I think, would expect to take probably 6 months to produce a judgment.
As I say, the unwritten rule is 3 months. Judgments have been treated as severely delayed 5 to 8 months. But I respectfully agree with...
Well, it depends on the circumstances. I mean, if you have a 2-day case and you don't produce a judgment for a year, that's an extremely severe delay. But
it is.
Trial of this length.
Yeah. But what we will see in the Court of Appeal's treatment of this point is that it doesn't matter if the judge's judgment was very thorough, for example. And I'll show you the passages in the judgment which say that. But the bottom line, as the Chancellor says, is that on any stretch of the imagination, this judgment is severely delayed. And although the judge said that he had gone away and reread the materials, I'm going to show the court that notwithstanding that, he still omitted to deal with important pieces of evidence that we submitted and the defendants recognised were an important part of our case. So, yes, the judge says it was a long, difficult case, but that doesn't provide an excuse in our submission for the failure to produce a judgment, as the Chancellor says, within 6 months. Instead, we have 15 months. Now, could we turn to page 1254?
Yeah.
And that's where we start on the effect of delay. The danger posed by a seriously delayed judgment in a case which involves assessment of fact and depends at least in part on the oral evidence of witnesses is that the delay may have so adversely affected the quality of the decision that it cannot be allowed to stand. Now, we then see what the then Chancellor said in paragraph 44 in St. Petersburg about the general unwritten rule, even in long and complex cases. And then at paragraph 45, we see that a delay of the magnitude in the present case, whatever the explanation may be, is plainly inexcusable. It should not have happened and should not have been allowed to happen, particularly in a case where there are allegations of dishonesty and reputations of future employment prospects of the individuals concerned. Nevertheless, it's quite clear from the authorities that delay alone will be insufficient to afford a ground for setting a judgment aside. However, the delay will be an important factor to be taken into account when an appellate court is considering the trial judge's findings and treatment of the evidence. And the appellate court must exercise special care in reviewing the evidence, the judge's treatment of that evidence, and his findings of fact and reasoning. So we accept, of course, that the mere fact of 15 months delay isn't determinative, but it is an important factor in the court's examination of the judgment. And then at paragraphs 46 to 51, we see the appellate approach to findings of fact in ordinary non-delayed cases. And again, we don't take issue with any of that. There's a high bar in an ordinary case, as I said in opening submissions, for disturbing findings of fact made at trial. Then the judgment moves on to consider the significance of delay, and we see, for example, that they refer to a number of cases, and what Lord Hodge says on page 1257, paragraph 55, the case of pickled properties plant. And then we see at 56 to 59, I'd invite the court to read from in Bond and Dunster down to the Court of Appeal in St. Petersburg, please. Thank you, my Lord. Now, I take a couple of points on this. Looking at the extract from Bond and Dunster, Lady Justice Arden there was dealing with a situation in which the judge has misrecollected some of the evidence. In that scenario, she says the court will order a retrial unless one of two things are true. Either the error couldn't be due to the delay in the delivery of judgment. It's not entirely clear what circumstances the learned Lady Justice had in mind there. But in our submission, it must be very difficult in a situation like this, involving complicated facts and oral evidence of witnesses. It must be very difficult to say that the delay could not have had an impact on the quality of the judgment. And as the court has said on numerous occasions, the advantage enjoyed by the trial judge in seeing the witnesses give live evidence diminishes to the extent that there is a serious delay in delivering the judgment. The second way to see the judgment, as the learned Lady Justice identifies, is if the appellate court can be satisfied that the first instance court, notwithstanding the error in respect to the relevant piece of evidence, came to the correct conclusion. So there are two ways. And one can imagine circumstances in which that might apply. For example, if the evidence which was disregarded was so obviously insignificant that it could not have affected the outcome.
Sorry, you put the test in terms of it could not affect the outcome. I'm not sure I read this, which seems to me to lay down the test with the qualification in 57, that it's not just applicable to failed recollection. This seems to me to establish the test.
Well, I'm going to show you what else the court had to say in this case, which sheds light on that and does support the submission that I made to your ladyship. But the test is, could it have made a difference?
Yes, that's not how Lady Justice Arden quite expresses it here, is it?
Well, what we have is the interpretation of the court in Bilta, and it is looking at the case law, and it sets out what we say is how this court should approach matters. It's setting out a synthesis of the cases, and in our submission, at the end of the day, if the court is not satisfied that the judgment was correct and that the evidence which was misrecollected, in our case not referred to, could have made a difference, then the court orders a retrial. And I'm going to show you some other passages in the judgment which support that. In 57, the Court of Appeal, paragraph 57, makes the important point that a misrecollection or a failure to deal with evidence falls into the same category. And so our submission is that there will have to be some form of retrial unless the court can be confident that the evidence, had it been considered, would have made no difference to the judge's conclusions. And as we see in 58, it makes no difference if the judgment was comprehensive and meticulous, as the judgment in the St. Petersburg case was found to do. A judgment given given timelinessly is assumed to be prepared with a full recollection of the relevant evidence. The judge doesn't mention a given piece of evidence. It will be assumed that he or she had it in mind, but did not think that it outweighed other evidence. So that's the normal way in which findings of fact are dealt with. But in a case where there has been severe delay, as in this case, the assumption is made, the opposite assumption is made. The judge doesn't refer to evidence, he's not assumed to have had it in mind. And the appellate review treats it as either having been forgotten or ignored. So that's an assumption which is made against, in effect, the learned judge. And one can see why, in that case, the appellate bar is relatively low. The judge is required to take all evidence into account. And then, if he failed to do so, unless the evidence could not have changed the judge's conclusions, it must be right that another judge is asked to consider all of it, including that which has been disregarded. Now, I would like to go to paragraphs 96 and 97. Where what the court says is this. This is where delay becomes a significant factor in this appeal. A judge is not required to address every point, and when a judge has evidence on which to base their findings of fact, the mere fact that there is evidence pointing the other way, which judgment does not address, is not a justification for allowing an appeal. Judgment given in timely fashion can be assumed to have been prepared with a full recollection of the relevant evidence. If it were possible to assume the judge had the hit list and the relevant emails in mind when drawing the relevant conclusions, then an appellate court could take the view that he did not mention the evidence because he simply did not think it outweighed the other material before him, which was supportive of his conclusions. Yeah. However, the 19-month delay means that we cannot make that assumption. We're in no position to say the judge's finding that questions were not asked at the dinner were plainly wrong. But in these circumstances, considering the significance of the evidence, which is not referred to, that is not the test. The question is whether we can be satisfied that the finding is right. We regret to say that we cannot. These contemporaneous documents support a view of the facts very different from the one the judge found. They do corroborate aspects of Mr. Gigax's evidence and could, for example, lead one to conclude that he had not given false evidence about the dinner, even if he had lied about his knowledge of VAT carbon trading. Now, there's another point that comes out of this judgment which is relevant to our grounds 4 and 5, and that is on page 1271 of the bundle, paragraph 115. And we see there the court saying the judge did not refer to the email to Mr. Metzler in his chronology. Did refer to the email to Mr. Metzler in his chronology, but did not refer to it, nor the other Awabi document in his treatment of the trader's evidence about the carbon desk dinner. So what the court is saying is, although you can see that the judge was aware of the existence of the particular document, he didn't take it into account, apparently, in the judgment when he was reaching the critical conclusion.
In the specific context.
Precisely. It's context specific. And
the fact that he referred to it somewhere else in the judgment doesn't
Precisely.
Mean that it's a killer, as it were, a killer point if he hasn't dealt with it in the specific context.
And if we then look at, I invite the court to read to yourselves paragraph 121 and 122.
Yeah.
You'll see that this could have made a difference.
So it's only if the court is satisfied that it couldn't have made a difference.
Exactly. And what is significant is, as the court says, it may be that when the matters are reviewed in the round again, you'll have the same result. The court can't say that is what would happen. So, in our submission, this judgment supports the propositions, the legal propositions we make in this case, and it sets the test for which the court has to examine the evidence that I'm going to directly the court's attention to, that the judge either didn't refer to or misrecollected. Now, I should show you, and I didn't yesterday, I think, maybe I did, a roadmap which we provided to the judge at the start of my closing submission. It's core supplemental bundle, tab 8, page 612. Core supplemental bundle. Tab 8, page 41. And as I say, I handed this up to the court in closing on day 32 of the trial, and you'll see at 2A, I've already been through this yesterday. 2B are the only means by which passive participants can rebut the presumption, the Anic presumption, public distancing and report to authorities. So we drew the judge's attention to that in closing as one of our main points. And while we're here, I'm going to ask you to look at under heading contacts referred to in waiting note, and at 612 below.
Where's that page?
Same page. 2B, what was, quotes, our intel about O2 not staying in phase for you, which Miss Rose referred to in November 2013. So that was, I'm going to come to that in due course, that was an important document that we relied on, that we cross-examined extensively, and this learned judge simply omitted to refer to at all. Now, in our submissions, we have identified a failure to account for or properly recollect evidence under 6 headings. A short point which I covered quickly yesterday about the context is that the MNOs resented the strength of indirects and wanted to get rid of phones for all CARFO and all both. They were suffering the prisoner's dilemma because they knew that in the past experience where Voda and O2 had left unilaterally had caused them loss and they had to go back. They were, in our submission, highly incentivized to collude. And in assessing whether, on the balance of probabilities, they did do so, the court needed to be alert to the fact that it's normal for collusion to take place in secret, for documents to be reduced to a minimum, and for the evidence typically to be fragmentary and sparse. And as I showed you the court yesterday, that's particularly so in this case. As the judge says in paragraph 94, it became apparent that very senior executives in the defendants paid scant regard to some of the recommended precautions in their internal competition compliance policies. There was a pronounced tendency for calls and meetings to be informal, attendance to be restricted, and documents kept to a minimum. That made it all the more important in our submission for all of the key evidence which did survive and which was relied upon the parties to be dealt with in the judgment. Yes, we accept this was a heavy case with a large volume of evidence, but the key evidence in relation to collusion was actually quite limited, understandably. But I make the general point, if there are 3 or 4 key pieces of evidence said to have a direct bearing on an allegation of collusion, it's pretty noteworthy for the judge to ignore any of those items of evidence. Still less to ignore more than one of them. Still less to conclude, as the judge did in one instance, that an allegation of collusion is plausible but unsupported by contemporaneous evidence when the majority of the contemporaneous evidence relied upon was simply not referred to. Now, I'm going to, in these submissions, break down the 6 grounds in a slightly different order than we've dealt with them in this.
You're going to come to that point that you just made.
Give me, my lord.
The judge finding that an allegation of collusion was plausible,
Yes,
but unsupported.
yes, I'm going to come to that. Yeah, that relates to Mr. Dunn. And
So
Lawrence.
which point does that relate to?
That relates to, you recollect that on the 19th of September there was a meeting between Mr. Dunn and Mr. Swanty.
Yes.
As we will see, there was also a meeting between Mr. Dunn and Mr. Lawrence of Vodafone.
Yeah.
And the judge found specifically that there had been collusion between those two because they both talked about EE's pricing. And following that episode, Mr. Lawrence approached Mr. Swanty in an attempt to persuade him to set the price for EE's 4G offering at £10, whereas they understood that they were going to set it at £5.
Yes.
So a premium price. It was. They were very, and I'll show you the evidence in relation to Landmark Lunch. They were concerned to ensure that it was priced at a premium level because they were concerned if it was not, there would be discounting, and who would be doing the discounting? The indirect retailers, and that would be reducing their profits by reason of what was going on in the market. But I'm going to come to that in detail. But when we get to that, you will see that the inherent probabilities established that there was no reason why, when Mr. Dunn sought to de-risk the provisional decision taken by O2 to exit phones for you, there's no reason at all why he wouldn't have had the same incentive to de-risk the decision of Mr. Lawrence. And I will expand on that in detail. Now, beginning with 2012, I'll be as brief as I can about 2012, at least as regards the Dunn-Swanty meeting, because the court has seen a good deal of that already in relation to my submissions in relation to grounds 1 and 2. As far as ground 4 is concerned, in this aspect, it's not relevant if the court accepts our submissions on grounds 1 and 2, but if the judge's legal conclusions withstand challenge, then the factual findings underpinning that need to be considered, in particular, whether he ignored material evidence which could well have made a difference. And the first piece of evidence is one that we have referred to as the green light note. And the green light note is in the core supplemental bundle at tab 14, page 56. Now, as the court knows, the learned judge found that Mr. Swanty responded passively to the approach made by Mr. Dunn at the meeting, and that the passive response did not give Dunn any encouragement that EE would positively, as he said, go along with Mr. Dunn's anti-competitive proposal. And that's what the judge said in paragraph 200. Now, if we understand the respondents' submissions under ground 1 correctly, they say that the judgment went even further and found that Mr. Dunn gained nothing at all from the interaction, not even a more limited indication as to whether or not EE was opposed to what O2 was proposing. But how they square that with judgment 225 is unclear, but that is what they seem to want to argue. But for current purposes, in our submission, the judge disregarded the only contemporaneous document disclosed by EE analysing whether there was a risk that Dunn had in fact been encouraged by Swanty's response, and concluding that there was such a risk. Now, Mr. Blendis, the General Counsel of EE, listened to Mr. Swanty's iPad recording, and he spoke to Mr. Swanty about it. He then had a call with Slaughter and May, asking for their advice. And this document, Mr. Blendis's document, shows at least some of what was discussed with Slaughter and May. Michael Rowe was the competition partner at Slaughter and And you'll see the second bullet point, risk that RD, that's Mr. Dunn, has gone back and taken the conversation as a green light. Now, what you have here is a recognition of the fact that non-opposition to an anti-competitive approach risks being treated as a green light by the approacher, and therefore inherently likely to distort competition. Now, this wasn't referred to by the judge, although we relied on it at trial, and in his permission judgment at paragraph 41, he said he'd not taken this into account. As he put it, that was not evidence about what had occurred at the lunch, but a solicitor's view as to what the legal risks might be. It wasn't relevant to the factual findings the court had to make. But whether or not Mr. Dunn took a green light from the lunch was a factual question. Its potential relevance to the legal advice which Slaughter and May were being asked for didn't stop it from being a factual question. Slaughter and May's assessment of the facts, far closer than a decade later, based on what it had been told, appears to have been that there was a risk that Dunn had taken the conversation as a green light. And in our submission, this is unbiased, contemporaneous evidence as to how the interactions between Swanty and Dunn at the landmark lunch appeared to an independent observer in October 2012. We say this item of evidence at least needed to be taken into account, and it was not. Now that sits alongside another piece of evidence relating to the landmark lunch, which was Swanty's own mixed evidence and cross-examination as to what impression Dunn had taken away from their meeting. And if we take out supplemental bundle 3, please.
So before you leave 6, 9,
My lord.
7,
Yeah.
can you just explain what the evidence was as to exactly what this is recording? Is this recording what Mr. Rowe said?
Yes. Yes.
All of it?
Forgive me.
Is all of it?
Can we just drop down? Can we just drop the page down?
So,
just to see the rest of it.
Yeah, of course.
Direct. Is that direct confirmed? Didn't confirm pricing.
Yes.
Haven't announced pricing.
That is what Mr.
Moved
Lent told.
Conversation onto Project Oscar.
Yes. So those are.
Move discussion on.
If we scroll back to the top, what did Olaf say in response to recent phone calls? That's a question from Mr. Rowe.
Yeah.
Next bullet, risk that RD has gone back and taken the conversations a green light.
So that's Mr. Rose telling Mr. Blendis of what the risk is.
And then
need to document our take.
To document our take. That is advice given by Slaughter and May to Mr. Blendis that you better set out in detail what it is.
And asking them whether there's been any subsequent email.
Yeah.
And then this is Mr. Blendis going back and telling Mr. Rowe what Mr. Swanty says.
Well, I think this was evidence of one single conversation, and during that conversation.
No, I follow that, but this, because I seem to recollect somewhere that this conversation between Mr. Rowe and Mr. Blendis comes after the transcript's been prepared.
No.
No?
No.
No.
What happens is this.
Sorry about that.
There's a conversation between Mr. Rowe and Mr. Blendis. Following the conversation, Mr. Blendis prepares a draft note, which includes details of the advice which has been given by Slaughter.
Okay, so that's the document our take point.
Yes. And that document, which is prepared by Mr. Blendis, is then further discussed with Slaughter and May, and Slaughter and May make comments on that document.
Right.
And that eventually ends up as the document we have seen at Judgment 158, I think it is, where the advice Mr. Blendis gives to Mr. Swanty, setting out the facts as he has been told them, and setting out Slaughter and May's advice. So the timescale is this: conversation with Rowe, then Mr. Blendis then prepares a detailed document which he discusses on the 23rd of October, 2012, with Mr. Rowe. Mr. Rowe gives his input in the document, and the finalised document, the 25th of October, is presented to Mr. Swanty.
Just going back to this one pager, the last 4 lines don't look like a record of the conversation with Slaughter and May.
Forgive me, my lady.
The last 4 lines, where it says Olaf with a circle, don't obviously look like the notes of a conversation with Slaughter and May.
Well, with respect, I think they do.
You think they are?
Well, what it does is he is telling Mr. Rowe that Olaf didn't confirm pricing, he hasn't announced pricing, and he moved the conversation onto Project Oscar. And the evidence which is in the judgment is that at the meeting on the 19th of September.
It might just be worth looking to see what the judge says about this, because if it's not challenged evidence as to what the course was as between the Mr. Blendis and Mr. Rowe.
I can also show you the cross-examination of Mr. Blendis. That would help.
Okay, so where are we? Round about.
Here in the judgment. So it's going to be
Is this
176, I'm told. Yes, 176 on page 311.
Yeah, it says. Yeah.
Mr. Blendis first spoke to Mr. Rowe on the telephone, and his contemporary note of the call indicates that Mr. Rowe, as one would expect, asked him to provide more information and advised EE should document our take on what happened. Mr. Blendis' evidence, consistent with the contemporary documents which are used when preparing his statement, is that this led him to prepare an account in the form of an email to Mr. Swanty, from which I've quoted above. Mr. Blendis went to see Mr. Rowe at Slaughter and May's offices on the 23rd of October and believes he would have discussed the draft email with Mr. Rowe. As I said, conversation with Rowe on the 17th, preparation of a lengthy document, which obviously contains advice which had been then given by Slaughter and May, taken to Slaughter and May on the 23rd, completed as a result of that, and then presented to Swanty on the 25th of October. But our point about this is that although the judge here refers to Mr. Rowe, Mr. Blendis' note, when he came to ask himself whether there had been any encouragement given, he didn't refer to the green light. As I've shown you, he says he didn't take it into account, and he gives a reason why.
Yeah.
Now,
so far as the email in its final form, the 25th of October,
yes,
the email is concerned, am I right in concluding the half of it's quoted in paragraph 158?
yes.
And the other half is quoted in paragraph 177.
I think that must be right.
Is that right? Because he says that he's
Yes.
quoted some of it at
Your
158,
Lordship's
and he then says the second section, Mr. Blendis' email, this merits quotation in full. So it looks as if that's tab 3.
Which one?
I suppose we could look at the whole thing.
Could I show you Mr. Blendis' witness statement?
Yeah,
on this?
sure.
Now, that's at Supplemental Bundle 1, tab 3. paragraph 55, page 72. Paragraph 55, I don't recall the specific details of my conversations. I've been shown a note of events, which I made in a notebook I used at the time, which records the following.
Yeah.
And there's the note that we have
Yeah.
seen. And then 56, if we made 73. Following the initial conversation on the 17th, I'm aware that I prepared a detailed summary of the factual background to the approaches, the initial advice from Mr. Rowe as to our options for responding, and our recommended course of action in the form of a draft email to Mr. Swanty, i.e. to document our take as per Mr. Rowe's advice noted above. Now, one of the things which seems to be said by EE in relation to this is that, oh well, this was just a preliminary conversation between Mr. Rowe and Mr. Blendis, and Mr. Blendis did not convey the full panoply of facts to Mr. Rowe, and he wasn't given the full panoply of advice. In fact, that's not consistent with the evidence, because following the initial conversation, Rowe prepares a detailed note which includes the initial advice from Rowe. And when we look at the documentary trail, I don't have time to do that at the moment, you will see that there is a fairly detailed note provided to Rowe, which is then debated. It doesn't change very much before it gets to Mr. Swanty. Where it does change is that Mr. Swanty, Mr. Blendis, forgive me, wanted Mr. Rowe to include in his advice that the risk of any comeback as a result of this connection between Dunn and Swanty was low. Mr. Rowe said, well, I can't say it's low. I can say it's contained or moderated, but I can't say the risk is low. And that isn't, I think you'll find that in the paragraph 177 the Chancellor directed my attention to on 312,
Yeah.
you'll see in the penultimate paragraph of that note, you'll see the risks of any action being warranted against your EE for your part.
Sorry, where are we?
Forgive me. You see the paragraph beginning given.
Given that no indication has
Yes,
been given.
exactly.
Yes, got you.
Yeah. So if you go down,
The risk of
says-
any action being warranted against you.
or EE for
Contained and moderated.
yes, and they want and Blendis had originally drafted it to say low, and Walter May said no, I can't say that.
Okay.
Okay.
So, what do you say that the note of Mr. Rowe saying risk that RD has gone back and taken the conversation as a green light?
Yes.
What does that add?
What does it add to? Well, it adds this, that it shows that the independent observer, Mr. Rowe of Slaughter and May, having been told the facts, considered that up to an objective observer at that time, there was a risk. Mr. Dunn, having not been rebuffed, had taken this as a green light. In other words,
That can only add if there was some fact he was told that caused an independent observer to think that, which isn't otherwise considered by the judge.
no, the judge's finding was when in 217 was that Dunn didn't go away with a consensus to cooperate or positive agreement support. So, if you're with me that is setting too high a bar, and as I've said, we don't need to worry about this particular item of evidence. But what this goes to is the question as to whether any encouragement was taken. In fact,
But it must. What matters
Well-
here isn't what Mr. Rowe said, but what was said to him that caused him to think this.
well, that's true. That's true.
So what is your case as to what he was told that
Well-
led him to think that
Well,
there may be a green light?
what he was told was what had happened at the landmark lunch. Now, obviously, we are not in a position to say, given the state of the documents which remain, we're not in a position to say what precisely he was told. But one would have thought that...
Did you call Mr.
Well, he must have been told, told, wasn't he, what's in the second half of the handwritten note about what Olav, because he asked the question, what did Olav...
He was told that.
What did Olav say? Yeah. He's told that, and isn't it in that context that he says there's a risk that Dunn has gone away and thought this was a green light?
Well, yes. I mean, he's told what happened. He presumably also tells Mr. Rowe that Mr. Swanty didn't cheerfully embrace the proposal, but simply sat there passively. And indeed, that's what one sees when Mr. Blendis plays back to Mr. Swanty the advice. You didn't encourage. But the important point from our perspective is that when an independent person is told about what had happened, he recognised that even if you're right, that there has been no positive encouragement, the mere fact that you say nothing in response to an approach of this nature risks giving to Mr. Dunn the green light.
Well, yes, it may risk it. Indeed, that's why we're here on ground one. But don't you need to go further? Because you're seeking to challenge the judge's findings of fact here. Yes. Don't you need to go further?
On this ground, yes.
And for example, say that what went in the detailed note that was later produced, that you've seen, is not the full story. Don't you need to go further and effectively challenge that description by saying, look, this is more contemporaneous evidence, this is earlier evidence, and you should prefer that?
Yeah, also, a sort of related point that occurs to me. This is Mr. Rowe's view of what he was told.
Indeed.
Was Mr. Dunn, what was that view put to Mr. Dunn? Was it said to Mr. Dunn, well, Mr. Rowe was right, wasn't he, Mr. Dunn? You went away thinking you've got a green light.
Well, certainly put to Mr. Swanty. Whether I put it to Mr. Dunn, I simply don't recollect. Mr. Dunn, of course, denied any of the anti-competitive approaches which we're alleging. He said, I didn't say any of that. So putting a green light to him may or may not have made any difference, because the answer would have been not in your life. But
because it's really what matters is surely not what the solicitor thinks the risk is, but what Mr. Dunn actually took from it, isn't it?
I see that, but this is secondary evidence.
But in light of the way you put the case yesterday,
yes,
and the way in which the direction in which, if you like, the arrow is going,
yes,
it's really what Dunn makes of all this that matters, isn't it?
Yes, and the question is, was Dunn encouraged? And
you say, well, there are lots of other bits of evidence which suggest that Dunn was encouraged, such as the subsequent approach to Mr. Lawrence, together with the fact that he comes back and has another go at Mr. Swansea about something else.
Absolutely.
But I'm not sure that this necessarily... I mean, I see it's corroborative evidence in a sense, but it's pretty... it's pretty secondary stuff, isn't it?
I accept it's secondary, of course. But we're in the position, as victims of collusion usually are, of having sparse material. And all I'm saying is the judge ought to have taken into consideration the fact that someone looking at this at the time thought there was a risk that that Dunn had taken that as a green light. Now, perhaps I could show you. I'm going to try and wrap this up as quickly as I can on this particular aspect. We can see what Mr. Swanty said when he was cross-examined by the judge. I mean, when he was asked the question of the judge.
Yes.
Supplemental Bundle 3, tab 112. at page 1409.
Yeah. Yeah.
Yes, if we could scroll down a bit, please. And while we're on page 90, and I put to Mr. Swanton, your concern is identified in this document, that it might have been suggesting they're willing to pull volume from the indirect channels with a view to protecting the value and wanted the volume not to be taken up by EE. That's what you understood, yeah. So that goes to the finding of fact that the judge understood what was going on. But if we go over to page 91.
Yes.
I'm on the wrong page. I'm on the wrong page. I'm sorry, I think yeah, sorry, 1412. 1412. Apologies.
Sorry, was this the wrong?
It's the wrong one. Page 1412.
Yeah. Which is
in the same tab.
Yeah.
Page, yes, internal page 135. Mr. Justice Roth at the top of the page, and the question is, well, did you not think there's a risk? He might think, well, therefore he can rely on you not to take up volume with the indirects. If O2 does pull away, yes, maybe, that would have been, yes, I mean, maybe, in hindsight. And then he says, well, he might not have taken very much comfort, but he recognised that there was a risk, that the
I'm sorry to be difficult. Can we just go up to 134 so we can see what the immediate preceding question was?
Yes, certainly, 134. At line 10, for example, but what he was saying, wasn't it, we might take some volume out and we'd like the comfort you're not going to step in and take it up. That's what he was saying at the lunch, wasn't it? That's how you understood it anyway. Yes. No, you didn't respond at the lunch. You didn't say, we won't, we will, you're quiet, you're silent, and I think the point that's been made to you is you do write to him a week, 10 days later, and refer to lunch. That would have been an opportunity where you could have put in something saying, yeah,
okay,
gotcha. So that goes to the...
And then if we go down, go to 135 again, please.
Yeah.
Could I just clarify the submission being made here so I can respond to it? Is it being said that this was the green light?
I don't think it is, no.
Because it isn't, so I wanted to just... I thought that was what the submission was.
I don't think this is. I think we've...
I'm sorry that my learned friend is labouring. I know there's that misapprehension.
Did not think there was a risky right there for me.
So, when the judge is considering whether there was any encouragement taken, all I'm seeking to show to the court are items of evidence which he did not apparently take into consideration as to whether any encouragement had been taken by Dunn from their interaction.
And you're saying that page 135, what is said there is another item of evidence that was not taken into account.
Finally,
forgive me,
my lord.
I managed to miss the reference. Which volume are we in now?
Which volume? We are in volume supplemental bundle 3 at tab 112, page 1412. Your Lordship, have supplemental bundle 3.
It seems to align with what I've got.
I'm finding that answer very difficult to understand, to be honest. Because the judge puts to him, this is one on 135.
Yeah.
The question is, well, did you not think there was a risk he might think? Therefore, he can rely on you not to take up the volume with the indirects if O2 pulls out. Well, that follows on immediately from him having sat there and said nothing.
Yes.
And then he says, so the answer is yes, well, maybe it would have been, maybe in hindsight it would have been better to be clearer. But at the end of the day, I don't think he'd got any comfort from me anyway, because on a day-to-day business to distribution, if he would move out and take some volume down, the teams would potentially buy it or not. Which seems to be saying, well, you know, as a matter of commercial reality, if we thought there was a gap in the market, we'd have taken advantage of it.
Yes, that's what he said.
But he then says, this was, but my lord, your point is valid. It would have made it even clearer if I would have said that we would not take on, we would not, you know, I don't know how you would phrase it. So that seems to be saying, well, maybe I should have been clearer in saying we wouldn't take on.
Absolutely.
He's got it wrong the wrong way.
As if he's got it round the wrong way.
Yeah, well, Mr Swanty's evidence was, if I can put it this way, mixed on this particular point, as your lordship has been
Yes.
identifying. But he did at least initially accept that there was a risk. And that's what I'm seeking to arrive at.
Well, he seems to be accepting that in this exchange here, doesn't he?
Yes, he does.
I'm desperately sorry to end this again. This is a part of the cross-examination dealing with whether Mr Swanty should have been clear when he sent a follow-up email. And one sees that at the bottom of the proceeding page. So that's what's he's being cross-examined on here. Otherwise I can come back to this in my response, but so we don't go off on a tangent.
Well, I think the point the judge is making is you didn't say anything at the meeting. You had a follow-up email to 10 days later. You didn't say anything in that either.
Exactly. Precisely.
So it's really the judge is saying you haven't said anything, as it were in the round. You haven't said anything.
Precisely.
And what do you make of that? And he's accepting that maybe he should have said something, whether it was something at the hotel or in the email. I think it's really both, isn't it?
Yeah, and that's all one needs to get out of it.
Yeah. Okay.
Now, the final bit of evidence relates to Mr Blendis' evidence, where in cross-examination, Blendis said that one reason that they did not protest the approach by Mr Dunn because O2 might have alleged that Mr Swanty played a more active part in the conversation than he and Swanty claimed. Now, in O2's skeleton, they quote from a passage in my cross-examination. Perhaps you would get this up. Supplemental bundle, tab 40, page 453.
We're in the wrong bundle, I think.
Supplemental bundle 2. Supplemental bundle 1 or 2?
O2 skeleton was in the core bundle, isn't it?
Yeah, your lordship's right. Forgive me.
Should be in the core bundle.
I'm sorry, but I've got a reference.
Core bundle.
Yeah. Tab 8.
Tab 8.
My learned Jim tells me.
Page.
One 184, I'm told. Yeah, finally, I apologise, we're there. 184 and 185.
Yeah.
At subparagraph B.
No, hang on.
185.
Is that
Hurrah. Subparagraph B
okay?
is a passage of my cross-examination of Mr. Blendis.
Yeah.
Now, we already had Mr. Blendis' evidence by this stage that he didn't. One of the reasons for not sending the letter of protest was a concern that there would be a debate about the direction of information sharing. In other words, that Mr Swanty had not been perfectly passive, as the judge ultimately found. And you'll see the questions I asked Mr Blendis, but the point of my cross-examination wasn't to show that Blendis had no concern. He'd already said that one of the reasons for not sending a letter of protest was that Dunn may have challenged the direction of information sharing. The point was, in cross-examination, was more subtle than that. It was intended to undermine the proposition that there was nothing on the iPad which could have given concern as to what Swanty said, or whether there was anything recorded that could have given any encouragement to Mr Dunn. That was what that was about. And again, that evidence does not appear to have factored in the judge's assessment. I am moving on now to a further episode from 2012. It relates to Dunn and Lawrence, which is the other allegation of collusion in 2012, but we haven't looked at this particularly under grounds 1 and 2. Our allegation was, just as Dunn had made a collusive approach to Swanty, equally he had made one to Mr Dunn, because it was, forgive me, to Mr Lawrence, because it was equally in his interests to de-risk the decision which they'd taken with Vodafone as it was from EE. The judge accepted several of our points about the inherent probabilities. First, Dunn and Lawrence were perfectly prepared unlawfully to collude. And the judge found that they did collude in relation to pricing on 4G. And one sees that in paragraph 238 of the judgment. And one needn't go to that. The judge also found that following Mr Lawrence's meeting with Mr Dunn, Mr Lawrence approached Swanty in an attempt to fix prices in relation to 4G. And that is judgment 165 to 169. This topic, 4G pricing, was closely related to the collusive approach to Swanty at the landmark lunch, which was also motivated by concern about 4G pricing and the role the indirect retailers would likely play in eroding prices. The judge also found that Dunn and Lawrence had a conversation later on how to best adapt and adopt the same strategy in relation to negotiations with Apple. That is judgment 236. This time it was Mr Dunn who was tasked with bringing Mr Swanty into the circle, and he approached Mr Swanty to do so, judgment 174. So that was the track record of Dunn and Lawrence. Second, in contrast to the somewhat frosty relationship between Dunn and Swanty, Dunn had a much warmer relationship with Lawrence. And as I said, the third critical point is that Dunn, who was keen to de-risk O2's provisional decision to exit FamesView, had just as much incentive to de-risk that plan with another MNO, namely Vodafone. Now, against these factors, nobody identified any aspect of the inherent probabilities which pointed away from the likelihood that Dunn would have made a parallel approach to Mr Lawrence. As to the witness evidence, the judge didn't appear to place any weight in Dunn's denial that he'd approached Lawrence, which was unsurprising given he'd rejected Dunn's evidence both on his approach to Swanty and on his discussions with Lawrence about price fixing. Lawrence didn't give any evidence.
No.
Ultimately, the judge rejected the allegation of collusion simply because, as he put it on the evidence, it was, quotes, too speculative. That's judgment 241. Now, one might consider that to be a rather surprising brushing off of a set of inherent probabilities which went all in one direction. But if the learned judge was going to take that approach, it was all the more important that he focused attention on key contemporaneous documents, which we relied on at trial, as supporting the allegation of collusion between O2 and Vodafone. And we suggest it was essential that when he came to test the inherent probabilities, he should have these documents in mind. He did not appear to have done so. Now, the documents which we relied on, my learned friend Mr Hoskins at trial said this in his closing submissions. We submitted the documents were particularly revealing, and as he put it in colloquial terms, Phones for You had placed its money on them. That was day 35, page 41, lines 3 to 7. It's actually in the supplemental bundle, tab 132, 1494. We didn't turn it up. But two of these three documents, which we had placed our money on, were not taken into account by the judge. They were an internal slide deck a few days before the landmark lunch, and an internal O2 message from Mr Evans to Mr Dunn. Can we have a look at the slides first, my lord and my ladies, which is in core supplemental bundle, tab 13, page 663, core supplemental bundle, tab 13. So what you see here is one of a lengthy slide deck, which was prepared for a off-site meeting in September 2012 in O2, and it was at that meeting which a provisional decision was taken to exit from Phones for You, which, as we've seen, Mr Dunn subsequently sought to de-risk by approaching Swanty, and we say obviously did the same, or had done the same, as far as Vodafone is concerned. And if we could turn on to 675, the following page, you see that it says at the top, there are events coming up that could generate the opportunity to break the current indirect model. And there are various, there's a timeline. And what I'm interested in for present purposes is note 5 at the bottom of the page. So it says O2 UK withdraw from Phones for You in January 2014 from both upgrades and gross at adequate volumes are being achieved through the direct channels allowing for greater bargaining power with remaining direct. Brackets. As soon Vodafone follows suit and existing Phones for You assets could be purchased for lower market value than current price. Now, nobody could explain at trial, when I asked them, why it was that an assumption was specifically made about Vodafone following suit. It's not an answer to that question, as the learned judge says in refusing permission, that it was just an assumption. The question is, specifically, why Vodafone in this context? Why was O2, shortly before seeking to de-risk its proposed exit with EE, already happy to assume that Vodafone would act in a helpful way? In our submission, this was prima facie, highly probative. It doesn't show that O2 knew for a certainty what Vodafone was ultimately going to do, but it does show an assumption that O2 felt it was in a position to make. In our submission, it indicates that O2 knew enough about Vodafone's thinking to consider that Vodafone's most likely response to an O2 exit would be to reduce rather than to increase its own Phones for You footprint. And in our submission, the document plainly needed to be taken into account. The other document in this context, which was ignored, at least in this context, was a text message from Mr Evans of O2 to Mr Dunn, dated the 2nd of January. And perhaps we could have a look at that.
2nd of January when? 13?
13, my lady, yes. And it's a core bundle, core supplemental bundle, tab 18, page 62. dated the 2nd of January. It's a text message from Mr Evans to Mr Dunn. Our gross connections through indirects were very high, potentially as a result of EE in dispute. Reassuring Olaf, giving our impending move, may be helpful to strengthen the operator's resolve against the indirects. Now, the impending move was O2's exit from selling new connections through Phones for You, a move which O2 recognised entailed risks for O2 and which Mr Dunn had already sought to de-risk by his approach to Swanty. Now, Mr Evans suggested in his oral evidence and cross-examined about this that the text reflected, as he put it, a poor thought which he did not act on. The judge, perhaps surprisingly, accepted that as an exculpation without really explaining why he accepted that. That's J, Judgment 198. But in any event, the important point for current purposes is that O2 saw a need, in view of its impending exit, to strengthen the resolves of the mobile network operators, including O2 and Vodafone, including Vodafone and EE against the indirects. And in order to ensure there was a strong collective resolve, O2 considered that it needed to make further contact with Swanty. Now, there's no suggestion in this document that further contact with Vodafone was required. The singling out of EE over Vodafone would only make sense in our submission on the basis that while EE's resolve was considered in need of strengthening, there was no similar concern about Vodafone. The important point is at this stage, Vodafone apparently gave O2 no cause for concern as far as its resolve against the indirects were concerned, and in our submission that could only have been because O2 knew from the interactions between Dunn and Lawrence, at a minimum, that Vodafone was broadly supportive of O2's pending move. The judge said that this text was relevant to the landmark lunch, and he referred to it in that part of his judgment, but irrelevant to Vodafone because, quotes, reassuring Mr Swanty has nothing to do with Vodafone. And he says that in judgment, permission judgment, paragraph 42. With respect, that does not follow. The message specifically referred to EE, but it did so in a context where, in our submission, a non-reference to Vodafone was only explicable on the basis that Vodafone, unlike EE, was in no need of further reassurance because of communications, conversations which had already happened. Nobody on the other side of the court was able to explain this text. And we submitted again that it was a significant probative piece of evidence. My Lord, I see the time.
Yeah.
You indicated yesterday we're going to take a break. That naturally is a break point in terms of the submission.
Well, can we keep it if we say we can be back here just before 1:15?
My Lord, yes.
We did that. Yeah. But that's not good.
real, in the first final, I didn't see the second one, which I think a lot of but yeah, so on Sunday, I took the girls down, because you know, they asked me and it was just unadulterated joy. People being absolutely bliss. AC Palace fan as well, yeah.
I did good.
Good point. Nice and warm for you. It's cold.
She was
I don't understand why you would say it to someone on the It confuses.
like, what do you think? That could have been any one of us.
It's interesting to me that her brain doesn't consider that it's a risk. Alright, message me when it's doing it. Otherwise I'll come back. That's what I'm saying too. I'll come back to you.
Stuff has come down, hasn't it? We need to look at it. I was just starting to look at it down.
So the second half.
I know, I was thinking, not for me.
It won't be.
No, I don't think it will be. Honestly, I did minimal. I'm very. No, I wasn't very little to do with it.
I'm certainly when I heard this.
Yeah, I think it's fine. I haven't seen it drafted just come out.
I'll ask her.
It's not actually online. So
Oh, is it?
If you, I've got it up. I started reading it, and I concentrate. How's Toby going?
She's going to this. She's maybe a year out. It's just interesting keeping it short because they're elevating every year. That's great. She's going to the absolutely. I think she's great.
What am I
sure I
saying?
want.
Oh, I think New York is so great. No, but I mean,
Why have they got some different supplemental funds and numbers to me? Why is that? You've got the same as me. So if I can get through this. We're watching something on the telephone. Of Malcolm. She's set in Argentina. She speaks Spanish. In Argentina, she speaks completely different. Pronunciation is for example, the double L.
Is sport ready?
Which would be it's Marbella. Don't pronounce it. He's missing. It's alright, I don't read instructions.
There it is.
But Donahue, that's a dirty underhand trick.
Rise of people.
My lords, my lady, moving on now to 2013 and an episode involving Mr. Hum of Vodafone and Ms. Castillo of Telefonica.
Yeah.
The judge made findings about their meeting in September 2013, covered in the judgment at paragraphs 287 to 292. Now, these two individuals were, of course, two of the executives named in the what we've been calling the Whiting Note, and the court, I hope, has in mind what I mean by the Whiting Note. That Whiting Note is at Core Supplemental Bundle, tab 22, page 992.
Have a look at that.
Yeah. Core Supplemental Bundle, tab 22. There we are. Just to remind the court, it's from Mr. Whiting to Mr. Lloyd. And you see that it refers to commitments being given by Ms. Sands to Mr. Hum, Ms. Castillo. So, I'm going to come to this document later, but as the court can imagine, that document was an important one in terms of Phones for Use case, and the judge made certain findings about it, which I'll come to.
Yeah, okay.
But these two individuals, Hum and Castillo, met in Madrid in September 2013. And at this stage, O2 had partially exited from Phones for You for the sale of new connections, but was still partially in Phones for You for upgrades.
Yeah.
In cross-examination, Hum accepted it would have been interesting intelligence for Vodafone to know whether O2 was going to go back into Phones for You. We needn't turn it up, but that's day 21, page 118, lines 17 to 21. Learning more about O2's intentions obviously would be valuable intelligence because it would inform Vodafone's views of whether, in considering its own potential withdrawal from Phones for You, there was any risk or likelihood of O2 coming back in opportunistically to pick up some of the volume Vodafone would be abandoning. And again, without turning it up, Vodafone's internal analysis in the summer of 2013 was that if O2 did ultimately re-enter Phones for You, that could be critical to determining whether Phones for You would survive the Vodafone withdrawal. So obviously important to know what the intentions of O2 may or may not be. Vodafone disclosed a manuscript note prepared by Mr Hum, which the judge found was made shortly before his meeting with Miss Castillo. Under the heading, quotes, UK, Mr Hum wrote the words, quotes, out distribution. In his written evidence, Mr Hum said this, and I needn't turn it up, but I'll give you the reference. Supplemental Bundle 1, tab 20, page 452. He said this, I think I was interested to gain a sense of whether Telefonica felt good about having exited Phones for You. However, I do not believe that I actually addressed this topic at the meeting. So, Mr Hum accepted that his intended topic of discussion was focused not simply on distribution in the UK generally, but specifically on Phones for You and O2's exit from it. The judge, for his part, rejected Hum's evidence that although he'd intended to discuss the topic with Ms Castillo, he did not in fact do so. And that's judgment 289.
Yeah.
But critically, the judge found that if Ms Castillo did tell Mr Hum anything about Phones for You, it was backwards-looking information, that O2 was doing fine, and that its move to reduce reliance on an indirect retailer in the UK market had not caused any problems. That's judgment 292. The judge said that since it didn't involve any disclosure of future strategy, it would not have constituted a relevant infringement. But there are a number of material documents pertaining to this meeting which the judge omitted to consider. One document relates to the judge's assessment that Ms Castillo was, as he put it, a highly accomplished business person who would not have participated in a conversation in which she unilaterally disclosed confidential business information. And the judge said that at paragraph 291 of the judgment.
Yeah.
Now that assessment sits alongside something else the judge said in paragraph 94 of his judgment, if we could look at that, on page 343, Core Bundle 1, tab 18. The judgment, page 285, no, 286.
This is the conversation between Ms Claimant and...
That's it, my lord, yes.
But this is a bit of the judgment where he's dealing with the disregard for the recommended precautions.
It is indeed. Now, so you see that he says that at the top of the 287, Ms 287, please. Going the wrong way. Line paragraph, yes. Ms Neymat of Deutsche Telekom had at least one conversation with Ms Castillo of Telefonica Europe, of which the subject matter is not reflected in any document, either before or afterwards. Now, the judge appears not to have recollected that a note of this call between Ms Castillo and Ms Neymat of Deutsche Telekom was in fact disclosed during the course of trial. Nor did he recall that this note appeared to show Ms Castillo participating in a unilateral disclosure of confidential business information, albeit this time as a recipient, about an impending deal between EE and British Telecom. And perhaps most surprisingly, the judge did not recall that Ms Castillo was cross-examined about this note, and that he himself observed in argument that she could provide no explanation for it. And the references for that, my lords and my lady, are in paragraphs 146 through to 148 of the judgment. Skeleton, forgive me, skeleton.
Which is page?
Page 64 of the bundle.
Core bundle.
Yes, core bundle, starting at page 63, 145. So we've got the point about paying scant regard to the precautions, and the reference in 94 I've shown you, there was no document. We say that correctly reflected the position at the beginning of trial, but in the course of trial, Telefonica notes written up by a colleague of Ms Castillo's were disclosed. Included a note, at least of some of the content of a call between Castillo and Neymat. Note was dated the 7th of October 2013 and headed Update Claudia. Miss Neymat's first name was Claudia, and her call was with Castillo was on the 7th. The note included in the following: BT, we do it in reasonable conditions. And the context for that was, in autumn of 2013, BT and EE were discussing signing an agreement in which BT would operate as an MVNO, mobile virtual network operator. Shortly after the call, EE announced that it had signed an agreement with BT. It was put to Castillo in cross-examination that she discussed EE's negotiations with BT, with Neymat. Phones for use submitted. Castillo's oral evidence was instructive. When asked about what she could have discussed with Neymat, she said unequivocally, I would never have spoken to Claudia Neymat on British Telecom. On being shown the note of the call, she repeatedly said she did not understand or did not remember. Quotes, I find it very difficult to see BT there. Counsel for Phones for Use submitted that Ms Castillo floundered trying to explain the document in cross-examination, at which point the judge observed, yes, she couldn't understand it, couldn't explain it. Now, this evidence was nonetheless not correctly recalled and not referred to in the judgment. In our submission, it, at a minimum, could have affected the judge's findings about what Miss Castillo would or would not have considered appropriate to discuss with a competitor, and as to whether she might have been likely to participate in a discussion in which confidential business information was unilaterally disclosed. This, as I've said, on this occasion, Miss Castillo being the apparent recipient of EE's confidential information. Now, there was also another contemporaneous note which appeared to show that shortly after Castillo's meeting with Mr. Hum, O2 was in possession of information about Vodafone's contract with Carphone. And we refer to this episode in our skeleton argument for trial, paragraph 144. Sorry? Yeah, skeleton argument, paragraph 144, if you go back to that, page 63. And the court sees what we said there. And one sees that during the closing, the judge asked Vodafone's counsel, just before you leave Castillo, do you want to say anything about her apparently having information about Vodafone's contracts with Carphone? But the judge didn't refer to this, or as to the defendant's explanations for it. Wasn't information about Phones for You, obviously, but valuable information about Vodafone's relationship with indirect distributors, which this evidence indicated had been attained at around the time of Castillo's meeting with Hum. And on the judge's approach, this information could have been part of a reciprocal exchange with Hum. However, I now come to what we submit was the most glaring admission in this part of the judge's treatment of the evidence, which concerns a document dated shortly after the Hum-Castillo meeting, which appeared to show what Vodafone had learned from Telefonica. It was an email sent by Miss Cindy Rose to various colleagues a few weeks after the Hum-Castillo meeting. And perhaps we could look at that. It's in the core supplemental bundle, tab 21. It's from Miss Rose, sent to herself and others, dated the 4th of November 2013. So 6 or 8 weeks after the Hum-Castillo meeting. And halfway down the page, Phones for You and O2. Phones for You claimed to be in renegotiation with O2 to either bring them fully back in or to fully kick them out. And Phones for You tell us that this will play out one way or the other by the end of December. Our intel suggests O2 is more likely to align with Carphone and come out of Phones for You completely. I think Phones for You know this, but they're telling us that if we have any interest in pursuing the attached proposal, then they need to know before they sign any new deal with O2. So using their renegotiations with O2 to put some tactical pressure on us. Now, the intel referred to in that paragraph was obviously forward-looking information in relation to O2's future strategy. And in particular, as to the approach O2 was likely to take to its relationship with Carphone and Phones. Now, I make clear, we don't suggest that Miss Rose was dealing in certainties. And if you look further down in the email, she says that she has asked Phones for You, which claimed to be continuing negotiations, under what terms it would kick out O2 and deal with Vodafone instead. Putting it that way might have been a bit of a sop to Phones for You in circumstances where Miss Rose was telling her colleagues that she did not really believe that what Phones for You was saying about the state of the negotiations with O2. But it might also have reflected whatever intel Vodafone had received, gave even an insight into what O2 was likely to do. And that fits with the state of O2's own deliberations at the time. When Miss Castillo met Hum, Telefonica had not made a final decision on whether to fully exit Phones for You. But as we note at paragraph 136 of our main skeleton, and as Castillo herself observed shortly after the meeting with Hum, exiting Phones for You was consistent with the distribution strategy which O2 Telefonica had decided upon. Now, of course, we will never know precisely what Ms. Castillo said to Mr. Hum. But if Ms. Castillo indicated something about O2's distribution strategy and the likelihood that it would not involve a presence in Phones for You, that is just the sort of information that Miss Rose could subsequently have referred to as our intel. In our submission, that plainly would have been interest and information of considerable significance to a competitor such as Vodafone. Learning more about the attitude of O2 to Phones for You would inevitably have informed Vodafone's thinking as to the likelihood of what O2 would do. The email, of course, does not compel the conclusion. It reflects, we say, that information passed by Castillo to Mr. Hum. But once one recognises, in the light of this email, the likelihood that a forward-looking conversation took place between Hum and Castillo, it must also be likely that the forward-looking conversation would have given some insight into O2's future strategy against Phones for You. This was all for the judge to consider had he taken this email into account. Now, as the court can imagine, this was a significant part of Phones for You's case, and Miss Castillo was cross-examined. Miss Rose was cross-examined extensively about it. And I've already shown you the roadmap document where we said what was the intel referred to by Miss Rose in her email, and the judge ignored that and did not deal with it. Now, perhaps I can show the court the cross-examination of Miss Rose in relation to this episode, was that core supplemental bundle, tab 55, page 1457 of the bundle. And if the court looks at, we need to go previous page. Previous page. 14.
Sorry, which tab of the bundle?
It's sorry, my lord. It's tab 55.
Tab 55. We were in that.
And I want page 1457, please.
I think we're having difficulty with the page numbers here.
Sorry, the supplemental bundle page, forgive me, is 156.
156.
Yeah, at the top, in red.
Okay, so we need to go up.
Yeah, I can start on page 151
Oh, okay. All right.
at line 9.
151.
You mean internal 151?
Internal one.
No, we're all over the shop here. I don't know what's
Sorry, my lord. 156.
Yeah, that's
Stop.
it.
Stop. Yes. Line internal, line 9 on the right-hand side. I hope the court can see. Question. Phones for you in O2. Claim to be in renegotiations. So I'm reading to her from the document.
Yeah.
So
So
you're
you're
putting
putting the
Intel is an abbreviation for intelligence, isn't it?
Mm-hmm.
She answers that straightforwardly, yes.
yeah.
Meaning useful information, meaning information. Okay. And then, before I have a chance to ask any further question, you'll see on 152, and if we can scroll up a wee bit, not necessarily inappropriately acquired. And then I ask, in what form did this intel come to you? And she says this: the intel I was referring to here was publicly available, industry speculation, and based, frankly, on common knowledge. I've been in the industry for 7 or 8 weeks, and it's very obvious to me the direction of travel. The operators are investing in their direct distribution networks, so you didn't really need inside information or intelligence to understand what was going on. It was common knowledge. Then I ask another question. You see the sentence is our intel. That suggests it's private information to you, doesn't it? No, sir. There was no private information. I had no private information, inside information, or inappropriately acquired information. You see, if this was simply market rumour, that wouldn't be confidential, would it? Are you referring to the subject of the email? No, I'm just asking you, it's an open question. Now, if we could go over. And the answer is because the negotiations were confidential, which is why I headed the email in that way. So is it your evidence that when you referred here to our intel, this wasn't in relation to any information that you'd somehow acquired from another participant in the market? Is that right? I absolutely had no information from any other player in the market, only industry speculation, publicly available information, and my own common knowledge and nothing more. If I was to suggest to you that the intel which you were referring to was something that Mr. Hum had conveyed to you as a result of a meeting with Telefonica a few months earlier, what would your answer be? My answer would be that Mr. Hum conveyed no information to me, and I pride myself on my integrity, and that's not what happened. Well, let's take that in stages. Sure, if Mr. Hum had conveyed information to you, you wouldn't necessarily assume that Mr. Hum had obtained the information illicitly, would you? In fact, you'd assume the opposite. Mr. Hum conveyed no information to me, so I didn't assume anything. Now, in our submission, the evidence of Miss Rose was that this was all industry speculation, publicly available, was highly implausible. Given the revelation that Mr. Hum had had a discussion with Miss Castillo about distribution in the United Kingdom, and specifically about O2 and its exit from Phones for You in the very recent past, the obvious source of our intel was not publicly available rumour or speculation, but the interaction between O2 and Vodafone in Madrid between Hum and Castillo. Now, as you saw...
Well, our intel does suggest it's something we've got that nobody else has.
Well,
as opposed to market rumour. And then she says it was market rumour.
She says it was market rumour, but that's obviously nonsense.
You might have said, well, market rumour is that...
she might have, but she didn't.
Our intel has...
Our intel. And when you ask, what could the possible source of this information be? The obvious source, we now know, is that there was a meeting between Hum and Castillo in Madrid. Now, you'll have, as I read to you, that on page 153, that Miss Rose says, Hum conveyed no information to me, and I pride myself on my integrity. Well, when the judge came to consider Miss Rose's vaunted integrity, he would have also had to consider the findings that, if he had considered this, the findings that he made that she was involved in deceptively stringing phones for you along with the aim of preventing phones for you from finding alternative sources of supply once Vodafone had decided to kick out phones for you. So she was prepared to deceive phones for you. And on our submission, what is obvious here is that her intel was a source derived from Mr. Hunt and his interaction with Miss Castillo. And I've already shown the court the roadmap document, and notwithstanding that, the judge took none of this into account. Now, if the position is that Vodafone had obtained some non-public information about O2's intentions to phones for you, then that could at least be fatal to the conclusions in the judgment, whether the conversation had crossed the line into unlawful consultation in Madrid, and whether Castillo had told Hum information which would be useful to Vodafone's ongoing consideration of the likelihood of O2 maintaining or recommencing a relationship with phones for you. Now, in his permission judgment, and in Vodafone's skeleton, they focus largely on causation issues. In fact, in effect, they say, even if this email was evidence of unlawful collusion, that would not have had any causal effect. The judge says this because Vodafone's decision to exit phones for you didn't come later, after it was public knowledge that O2 had fully exited from phones for you. But that's no answer to the question with respect as to whether Vodafone obtained information as to its attitude to phones for you, which was of continuing relevance. Any information which had bearing on O2's attitude to phones for you would have been critically valuable. And it's difficult to see how Miss Castillo could have indicated, as she did in her intel document, that O2 was, quote, likely to align with Carphone Warehouse and cut ties with phones for you without giving some indication of O2's strategic attitude to longer-term future relations with the two major indirect distributors, namely Carphone and Phones for You. And in our submission, these are plainly matters which, at a very minimum, the learned judge needed to consider. Vodafone, for its part, says that even if there was a disclosure of forward-looking information and therefore a prima facie infringement, the Anic presumption was rebutted. But the learned judge did not remotely say that, and we've given the references at paragraph 73 of the supplemental bundle, which don't turn up. More fundamental point is this: there can't be any dispute that the Our Intel email was critical evidence, which could well point to the conclusion that O2 Telefonica had provided unlawful, forward-looking information to Vodafone, and that would prima facie be an infringement. So Vodafone is left asking this court to make factual determinations as to the causative effect of such unlawful consultation. In our submission, that's desperate. If the evidence, as we say, did supported a prima facie infringement, it wasn't taken into account, and the judge's findings fall to be considered in the light of all the disregarded evidence. 2014. Turning to the alleged collusion between EE and Vodafone. And you'll recollect that we've already looked at this to an extent under Ground 3. Context is that by January 2014, O2 had exited completely, leaving EE and Vodafone as the two suppliers. Each of them faced the risk, if it exited, a great deal of volume would go to the other, and Phones for You might pull in another supplier, such as BT. But it was obvious that if they exited Phones for You simultaneously, Phones for You's business would be fatally undermined. With only one MVNO, one other MVNO supplying Phones for You, EE and Vodafone, MNO, the prisoner's dilemma became simple. Genuinely independent conduct still exposed the MNOs to unattractive risk, but de-risking such an exit simply involved finding out what the plans or intentions were of the competitor. Our case was that these two MNOs collusively exchanged information about their plans and intentions. We relied on a significant body of evidence, which I can't take you through in great detail, but I'm going to begin with the evidence of the Sheen-Hum communications in April 2014. As I've said before, in many cases of collusive communications, the sole focus will be on establishing that information was communicated rather than how it was communicated. There'll often be no way to know how the information was communicated, but that's obviously not a necessary part of establishing an infringement. One has to establish that the information was communicated, not how. But in this case, in our submission, there was potent evidence showing how evidence may well have been conveyed, misrecollected or disregarded by the judge. Our case was there was at least one likely culprit, and that is the telephone call that Mr. Sheen initiated with Mr. Hum. In our submission, this was one of the most surprising and troubling episodes in the case. It only came to light as a result of the production of Mr. Hum's mobile phone records. Mr. Sheen's phone records, emails, had not been preserved. Now, it had some similarity with the landmark lunch, only this time it was the EE undertaking rather than O2 making a nakedly collusive approach. And as the court knows, the learned judge dealt with this episode towards the back end of the judgment, at paragraphs 562 on page 420. Under his heading, a series of unfortunate events. Now, in doing it there, he separated it from the main chronological discussion of the documents and witness evidence. And if we can put a metaphorical finger in that and go back to judgment 467 on page 392, you'll see that 467, he refers to a telephone conversation between Mr. Policier and Mr. Dannenfeld. And then it jumps to the 10th of April BRM in 468. Now, there's no placeholder there for what happened on the 2nd of August.
2nd of April?
Yes, April. Forgive me.
2nd of April.
April, yes. Now, the key remarkable facts are then dealt with out of sequence on page 420 of the bundle at 562. And one sees that on the 2nd of April, Mr. Sheen of Orange, who was also a director of EE, sent a text message to Mr. Hum. Hello, Philip. I'd like to talk to you for 5 to 10 minutes max regarding a topic for the UK market. When can I call you? Possibly today or tomorrow. Thanks. Benoit Sheen, Orange, Europe. Now, when he was cross-examined about this, and as the judge records in, I think, paragraph 569 of his judgment, Mr. Sheen said, quotes, it was very, very, very unusual to be contacting a competitor in this way. Although the judge refers to the fact that he said it was very, very unusual. In fact, he said it 4 times. Mr. Hum responded without asking what the topic for the UK market was that his competitor wished to discuss. And he said, can I call you today post 3 p.m? And you'll see that in paragraph 564 of the learned judge's judgment on page 420. A minute later, and I don't think the judge caused that, a minute later, Sheen responded, "That's fine, please call me on this number, thanks Benoit," and gave him a number. You'll see that in the core supplemental bundle, tab 28, page 79, if you wish to look at it in due course. Mr. Hum's phone records indicate a conversation lasting about 5 minutes then took place later that day. Now that was then followed by a further text message from Mr. Sheen to Mr. Hum, which you see recorded in paragraph 566 of the judgment. After review, I'll unfortunately not be able to come to London before several weeks, but we then organise a secured call, with both of us using a new prepaid number. If we're both using a new prepaid number, the call will be secured. I could have a prepaid number being ready for tonight to have a potential call tomorrow. Would this be a suitable solution for you? Then we see the response from Mr. Hum the following day. "Hello, Benoit. Not knowing what you want to discuss, I feel not comfortable about making these sorts of arrangements. If there is a topic we need to discuss or decide, suggest to arrange for a call together with a competition." And then that produced a further response from Mr. Sheen. "I don't want to force you into a setup that you don't find suitable. I wanted to address a potential interesting joint opportunity in the UK market in an informal way. So I don't think that the presence of a lawyer would be suitable at this stage. And let me reassure you, my intents were positive and constructive. But I guess that we will have to look at it in a different way, as potential decisions will have to be taken in the coming weeks. It is maybe a missed opportunity for our respective companies." And then 568, you see the judge says, "Mr. Sheen and Mr. Hum both said there, no further contact thereafter. And there's no evidence to suggest the contrary." Now, Mr. Sheen and Mr. Hum obviously had time in the initial conversation to reveal what this topic for the UK market was that Sheen wished to discuss with Hum as a matter of great urgency. As the judge noted, Mr. Sheen eventually accepted in cross-examination. And we'll see that in paragraph 570 on page 421 if we scroll down. Mr. Sheen eventually accepted that in their 5-minute telephone conversation on the 2nd of April, he would have told Mr. Hum, at least in general terms, what he wanted to discuss. It seems to me inconceivable that after the initial text, Mr. Hum would not have asked what was the topic for the UK market which Mr. Sheen wanted to talk about. In which case, Mr. Sheen would have answered the question, although I accept that he may not have entered into many detail. Now, it follows that whatever the topic was, it was known to both men by the end of the 5-minute call, and Sheen proposed continuing that call, as we see, as a matter of urgency, on burner phones. So there were two important and interrelated questions. What was this topic that Mr. Sheen wanted to raise on the call, and what was communicated between them about the topic? And in our submission, those questions are obviously interrelated, because while raising certain topics might, if the topic is only identified or traversed briefly, transmit no useful information, some other topics, even a discussion of the nature of a topic, would inevitably convey business-sensitive information, still more so spending 5 minutes on it. Now, as to what this topic was, Mr. Sheen suggested in his witness statement that it was about a network sharing project. And we see that the judge refers to that in paragraph 571 of the judgment.
Yeah.
And he rejected that as being extremely unlikely. And as the learned judge indicated, altogether he found Mr. Sheen's evidence about this exchange evasive and unsatisfactory. And as the judge observed, there was nothing about a network sharing project which could explain a resort for use of burner phones. Now, as far as Mr. Hum's evidence about this exchange is concerned, he said he couldn't recall the topic of the conversation, which, as I said, the learned judge at 569 found surprising. So we then have two witnesses who gave unsatisfactory evidence about the subject matter of the call and the text messages. And the topic was definitely not network sharing. So what was this topic that Mr. Sheen was in such a hurry to discuss with a competitor, and that was appropriate to continue using a secured method of communication? Orange's faint submission at trial was that it was plausible that Mr. Sheen wanted to discuss network sharing. But as we've seen, the learned judge rejected that as extremely unlikely. Orange did not suggest at trial that the topic for discussion was a possible joint venture acquisition of Phones for You. Mr. Sheen did not suggest in his written or oral evidence that a joint acquisition of Phones for You was a topic he was in such a hurry to discuss with Mr. Hammer. The judge nevertheless concluded in paragraph 574 on page 422 that I consider that what Mr. Sheen therefore wished to discuss was whether Vodafone would be interested in a joint acquisition of Phones for You. And in paragraph 573, my lords and my lady, you'll see that the judge said, quite correctly in our submission, I think it's important to consider this exchange in context. Now, when we look at the full evidential context, as the learned judge did not do, we would submit that on this aspect, the judge was plainly wrong. And even if we did not have the approach of the court in NatWest and Bilter, we'd have suggested that this finding was perverse. But be that as it may, the NatWest approach being pertinent, we say we only need to show that the conclusion was made in disregard of material evidence which could have made a difference. Now, the judge in 573 referred to two matters: the EE Business Review meeting on the 20th of March 2014, and a part of what Mr. Sheen said in his witness statement about a joint acquisition. Now, those were apparently the only two pieces of evidence said to support the proposition that Sheen considered a joint acquisition to be such a good idea, such an interesting opportunity, that it required urgent discussion with Mr. Hunt on burner phones, and a discussion which could not take place in the presence of a competition law. But as we shall see, even just focusing on the BRM of the 20th of March and Mr. Sheen's witness statement, the judge omitted to refer to critical evidence there. The documentary record is in our submission, the surest guide to what it was that Sheen wanted to raise with Hunt. And we ought to look at the Business Review meeting on the 20th of March, which is in the core supplemental bundle, tab 25, page 73 in red at the top. And if we could have the whole of that, yes.
Yeah, slightly earlier. Isn't it? This is 19th of February 2014, not 20th of March.
Oh, sorry, it's 73. Forgive me, 73.
Yeah.
EE Business Review, 20th of March, written by Mr. Harris. Please remember Mr. Harris's name because he will feature later on in my submissions. And you'll see the participants: Mr. Swanty, Mr. Milsom, Mr. Harris, Mr. Nolo. Mr. Nolo was an employee of Orange who was referred to as a front door. He was involved in day-to-day activities on behalf of Orange as a shareholder, and he attended many of his meetings. Then you have his counterpart at Deutsche Telekom, Wolfgang Knieser, and Mr. Sheen, director of EE, Mr. Alera, and Michal. I can't tell you who Michal is, but it doesn't matter. Now, if we could turn to... Yes, he's a DT person, Mr. O'Donoghue helped me, reminds me. Now, if we could look at page 75, and your Lordship was right to refer to the fact that it says the 19th of February. This was explored at trial, and it turns out that what Mr. Harris's modus operandi was to take previous minutes, use it as a template, and prepare minutes for the particular meeting. So the document is in fact relating to the meeting on the 20th of March. It's just he hasn't corrected this at this stage.
Right.
So that's what that's about. And if we look down to the heading distribution, please, and stop there, you'll see that Wolfgang Knieser, that's 1, 2, 3, 4 boxes down, queries why he couldn't exit phones for you. Then Mr. Harris comments, EE represents 6% of trading and are aligned on value. Then Mr. Olera says the intention is to reduce intensity. Mr. Sheen then says less dependence on indirect channel has to be better for EE. Dixon's, DSG is Dixon's, and Carphone would be a very strong player with phones for you weakened, but their reliance on operators is not clear. Then Mr. Milsom observes there were strong MVNOs who could step in and replace MNOs. Mr. Olera says phones for you could pull in MVNOs to replace EE and has 18 months to do so. And that is relevant, as I indicated to the court earlier on, because you'll see a volte-face or a Damascene conversion as far as Milsom and Olera are concerned when it comes to whether phones for you will survive an exit or whether it will start. But if we can go over the page to 76, you see Mr. Sheen's last contribution. 1, concur difficult to stop the merger. That's between Carphone and Dixon's. Need to keep in mind long-term objective and need to reduce dependence on indirect. If merger goes ahead, may make sense to exit phones for you. So that's the BRM of the 20th of March, which provides no support for the proposition that Mr. Sheen was in a hurry to discuss a joint acquisition between Vodafone and EE. Now, the next document that the judge failed to refer to in this context is extremely significant. It's at I'm sorry. Yes, core bundle 23. Core supplemental bundle 23, page 69 at the top. Sorry. Now, this is an email dated March the 31st from Mr. Nolot to Mr. Sheen, where he tells him that Gervais, who is Monsieur Pellissier, the other Orange director on the board, had a call with Thomas Dannenfeld, the Deutsche Telekom director on the board, and I prepared this short note for him this weekend regards Christoph. Now, if we go back to the judgment, at paragraph 464, where the judge is dealing with the chronology. I already made the point that he didn't deal with the Sheen Hum. 464. Page 391. You'll see it says this: Mr. Nolot set out their views in an email from Monsieur Pellissier on the 30th of March, where he wrote the approach of offering Carphone support for the Dixon's merger, etc., etc. So the judge refers to the communication between Nolot and Pellissier. What he does not do is refer to the fact that on the 31st of March, that email was forwarded by Mr. Nolot to Mr. Sheen. So when you come to read the submissions made by Orange on this appeal, you will find that their submission, that Mr. Nolo's email to Mr. Sheen on the 31st of March was referred to, is wrong. The email of the 30th of March was to a different email, to a different recipient, and on a different date. If we could go back to the Nolo email, tab 23, page 69 of the core bundle. Made these submissions. If the BRN notes that you've been looking at were an unlikely trigger for an urgent call, Mr. Hum, 10 days later, then this email sent on the 31st of March, only 48 hours before, was in our submission a much more promising candidate. Now, the email contains various points for Mr. Policier to have and a discussion to have in mind in anticipation of the call with Dannenfeld. And item 3, if we can scroll to that, please. Yeah, keep it there. Concern indirect distribution. Now, one sees that Nolo is saying to Policier the prospective merger between Carphone and Dixon is seen as affording a, quote, unique opportunity to break EE's extreme reliance on UK indirect distribution. And you'll see that it said that there's a window and a lever, depending on whether EE announces that the support for the merger or not. Merger changes from a merger between equals. If he supports it, it becomes more advantageous and valued to Dixon's, which is much less dependent on operators than Carphone, if he does not support. Then it says this: we, i.e. Orange, thus note a scenario for EE to explore, negotiate our support for the merger with Carphone in exchange for an end to RMS, that's revenue margin share, and a withdrawal from EE distribution at Phones for You. And then this EE is more inclined to analyse, with the support of M&A shareholders, a scenario of acquiring Phones for You, possibly with Vodafone, and then sharing and rebranding the 400 Phones for You stores. Then, if I understand from Wolfgang, that's Knieser, that Dannenfeld's position is first and foremost to do everything to weaken the excessive weight of indirect distribution in the UK. Then, in this regard, during the controlling review at Paddington, MCL, Madame Lambert, it's an EE employee, Orange employee, does not support at all a scenario of acquisition of Phones for You, which O2 has just left, but on the contrary recommends to move forward on a costed analysis of our more breakaway scenario of stopping revenue margin share with Carphone and withdrawing from Phones for You. Now, it's plain that this unique opportunity is obviously not an acquisition of Phones for You. It's clear from the email itself, and Mr. Nolo confirmed that when he was cross-examined about this. We can see that in supplemental bundle at tab 119, page 1449. That's page 63, line, 62, line 24.
Yeah.
By this stage, I mean by the 30th of March, as far as Orange is concerned, Orange did not regard, and if we scroll up, acquiring Phones for You as a unique opportunity to break the extreme dependence of EE on indirects, did it? I think this is correct.
Yeah.
Now, reading the judgment, one would have no idea that immediately before Sheen identified an interesting joint opportunity to Mr. Hum, Mr. Nolo had told Mr. Sheen what Orange considered to be a unique opportunity. And that involved exiting from Phones for You. even the original email from Nolota Policier, whilst noted in the judgment, figures nowhere in the judge's consideration and assessment of the context of the Sheen-Hum phone call. I've shown you paragraph 464 of the judgment. It isn't even cross-referred to later on in the section where the judge makes these findings. As I've said, that email to Sheen was not referred to anywhere. In our submission, this is the most glaring and serious omission. It is the most immediate, on the face of it, telling piece of context for his approach to Hum. Taken together with what Sheen is recorded as having said at the BRM some 10 days beforehand, none of this suggests that Orange in general, or Sheen in particular, had any interest whatsoever in an acquisition of phones for you, whether by EE on its own or as a joint venture with Vodafone, and certainly not something that Sheen would be responsible for taking forward and should raise as a matter of some urgency with Mr. Hum. On the contrary, the only opportunity which Sheen identified at the BRM, also identified to him by Nolo, was the opportunity of leaving phones for you. Now, as you can imagine, Mr. Sheen was cross-examined extensively about this Nolo email, and he was extremely reluctant to agree that he understood that Orange perceived a unique opportunity to break the extreme reliance of EE on indirects. And if we could look at that, it's at Supplemental Bundle, tab 120, page 1454. Starts at 1453, I think. If we scroll up, and it starts at the top in 50s, internal 57. I'll scroll a bit more. Now, if you could read to yourselves from 57, line 5, down to, let's say, 59, down to 60, line 2.
Just give us the bundle reference. It might be easier to look at it in the bundle rather than relying on the screen moving. What's the reference again?
It's supplemental bundle, tab 120. Now I've got, for some reason I seem to have different numbers of supplemental bundles, but it's tab 120. You may have it in bundle 4, I have it in bundle 3. I don't know how that's happened and I apologise. 1450, tab 120.
So what's been referred to when you got it? Is this the email?
Yes.
Right. The 31st of March.
Yeah, that's it.
Okay, and from page 57, is it?
Yeah.
Sorry, my lord, I didn't hear.
57.
Yes, page 57 from line 5 onwards down to 60, line 1. Now, so that is the rather evasive way in which Mr. Sheen responded even to the judge's questions. And if we could look at, now that you have the bundle, at page 1454 in the bundle, towards the bottom of 62, internal numbering, there we are. And I say to Sheen at line 15, let me put it this way, as far as you can recollect, there was no one at Orange who supported the idea of EE acquiring phones for you, either on its own or with another MNO as a joint partner. Is that correct or not? I cannot comment on that because I don't know if you're mentioning you know anybody or nobody. I think that again at the time all the options were still open. Okay, let me bring it a bit closer to home. What about you? Did you think the acquisition of phones for you by EE was a good idea? That would not have had my preference. And I've already stated that also in my witness statement. That's consistent with what he said in his witness statement, that he would have been sceptical about a possible acquisition of phones for you. And one sees that, I think, in the core supplemental bundle. At tab 2, page 15 in red at the top of the page.
Sorry, where are we?
We're now in Sheen's witness statement, core supplemental bundle 2, page 15 at the top, paragraph 32. I believe, as a general matter, I would have been sceptical about an acquisition. Now, consistent, of course, with what we see recorded about what he said, the BRM on the 20th of March. But the judge didn't refer to this scepticism. Moreover, as I've shown you, when asked, Mr. Sheen was not able to identify a single person at Orange who thought the acquisition of phones for you was a good idea. And that is evidence which the judge ignored. It wasn't the only evidence, however. You can see what Mr. Nolot said. Your Lordship has out already the bundle, and if you turn to tab 119 in the bundle. Sorry? What?
Sorry,
Yeah, it's a supplemental bundle, mate. Forgive me, supplemental bundle. Tab 119. Page 1448, internal paragraph 40, internal page 46, scroll down please. And I put it to him, we've agreed, haven't we, that Orange was never supportive of the idea of acquiring phones for you. That's right, isn't it? And he says, let's say some senior executives in Orange were mentioning their low appetite for that. Yes. Okay. Who in Orange, to your recollection, expressed any appetite for the possibility of acquiring phones for you? I don't know one. No, nobody in Orange, but Judge, nobody, nobody in Orange. In the same bundle, supplemental bundle, Mr. Dannenfeld's evidence, which is at tab 118. On internal page 1443. At the top in internal page 63, I put it to him. Now I think it's right, this is line 6, that you accept that Orange was dead against the idea of an acquisition of phones for you, correct? Answer, yes. The court should note and reject.
Sorry, where are you reading?
Forgive me, my lady.
63 line.
63 line 6.
Thank you.
You see line 6.
Dannenfeld.
Mr. Dannenfeld, Deutsche Telekom, also director of EE. Lines 6 tonight. Now, I was going to submit that the court should note and reject the rather desperate suggestion by Orange that Dannenfeld might not have appreciated the nuance of the phrase dead against when he agreed it as a summary of Orange's stance. That's, we need to turn it up, paragraph 19F of my learned friend's skeleton argument, core bundle, page 143.
Well, the answer at lines 15 to 18 is the light of that, isn't it?
Mm.
Because he says in terms that, and he said it in his statement, that Marie Christine Lambert was very much against that.
Yes.
And she had a very strong position in Orange.
She did. And I mean, I was going to show you, perhaps I don't need to, but I'll just give you the references for this, that Mr. Dannenfeld demonstrated his grasp of English in describing Orange's opposition to indirect distribution as religious and extreme. That's the tab 118, 1442. In fact, if you look over, you've got the bundle open. You see on internal 60 at line 4 to line 10. Now, the picture in our submission, which emerges from the documents and from the witness evidence, is one of deep scepticism ranging to outright hostility. Any idea of the acquisition of phones for you on the part of Orange and its directors on the EE. Having regard to this key context, which the judge does not refer to in his judgment, it's impossible in my submission to reach a conclusion that the most likely explanation for Sheen's approach to Hum was that he wanted to discuss with Hum the possibility of a joint acquisition of phones for you. But, as I've said, in the light of the NatWest test, we don't have to go that far. The question is, could this material, properly considered, have made a difference to the conclusion that what Mr. Sheen was about was discussing urgently a joint venture acquisition, and we submit plainly it could have made a difference. Is it more likely that Sheen wanted to discuss with a competitor a course of action which he was personally sceptical about, that no one at Orange or Deutsche Telekom actually supported, which would have cost hundreds of millions of euros to pursue, or that the topic was the unique opportunity presented by the Carphone and Dixon's merger, which Nolo highlighted to Sheen 48 hours before he chose to approach him. Now, we also know that exiting from Phones for You was precisely what EE and Vodafone proceeded to do a few short months later, and that the idea of a joint acquisition never got off the ground. Now, as to what exiting Phones for You would have entailed, sounding out Hum or going further and raising the opportunity to pursue a joint exit in whatever level of detail would have provided very significant business intelligence to Vodafone about what EE might do. It would also signal to Vodafone a willingness to collude and a preference for strategic cooperation over competition. This is an example of a topic where the mere brief conveying of which would impart business sensitive information in breach of the strict prohibition against consultation and contact between competitors. If EE was keen enough on a Phones for You exit to raise with Vodafone the prospect of exiting jointly, that would have told Vodafone a great deal about where EE's thinking was. The mere raising of that topic, no rebuff from Vodafone, would constitute prima facie unlawful consultation. Once the premise for the judge's reasoning that the topic raised was a possible joint venture falls away, as we submit it must also follow that the remainder of his reasoning that no confidential information was imparted falls away. As we've seen from the first text message from Sheen to Hum, he thought he needed only 5 to 10 minutes to reveal to Hum the topic which he wished to pursue. He got 4 seconds. short of that 5 minutes in his call. And obviously what Sheen revealed to Hum was sufficiently interesting for them both to agree to a face-to-face conversation in short order. Now, and that's what led to the special arrangements for a call when Sheen couldn't come to London, apparently, for a call on a burner phone. Now, that leaves the response that the court has seen about what Mr. Hum said in the course of these exchanges. And if we look at that, paragraph 567, page 421 of the core bundle. We see the message that Mr. Hum sent back, not knowing what you want to discuss. That was the judge found in his judgment that Mr. Hum was being less entirely frank and that he perhaps knew more about the topic than he was letting on. Let's not beat about the bush. This was a lie. Mr. Hum knew what the topic was, and this exchange was, as I put it to him, an artful papering, laying a paper trail in case someone found the text sent by Mr. Sheen suggesting a burner phone. No doubt there could have been more to discuss, as was evident from the fact that there was going to be potentially a meeting in London and more detail given by either MNO.
Well, given that he spent 5 minutes on the phone to him, the idea he didn't know what it was Mr. Sheen wanted to discuss is just not sustainable, is it?
Not at all. And it follows. That's what the judge said. But the judge didn't join the dots.
No.
We say he ought to have said that text which came back, not knowing what you want to discuss, was a blatant lie.
I mean, he said the judge deals with that in 570, doesn't he?
Yes.
Where he says it inconceivable that they wouldn't have discussed what the topic was, so he didn't know what it was they wanted to talk about.
Yeah, and then we see in 575, he says it may be that it was strategically worded. That's, as I say, being kind to Mr. Hum. Now, we have dealt with some of Orange's submissions on this aspect, and Orange have taken the lead in dealing with this aspect of our case. Orange doesn't make any submissions at all about this court's decision in Bilton, and they don't even mention it in their submissions. And it may explain in our submission why Orange's submissions are seemingly aimed at the wrong target, trying to defend the judge's conclusions against a submission that it was perverse or plainly wrong. Even if those submissions are well founded on their own terms, it wouldn't matter. As the court made clear in Bilton, where a judgment is seriously delayed as this one is, it's not an answer to the complaint, that the court failed to consider material evidence to submit that it had a basis for reaching the conclusion it did. It can't be shown to be plainly wrong. That's not the test. Orange's erroneous approach appears from paragraphs 15 and 16, which I needn't turn up, but Core Bundle 1, tab 6, page 138, where they submit there were ample grounds for the judge to reach the factual findings. Well, as I've submitted, that isn't the test. Now, even an Orange say that Mr. Sheen did not say at any stage that he was a priori against a joint acquisition. Paragraph 19A of this goes on. But even if, contrary to the evidence, Mr. Sheen was not initially conclusively opposed to an acquisition, that takes Orange nowhere and would not justify failing to address all of the evidence on this subject, which I have been showing to the court. Moreover, the lack of settled opposition to acquiring phones for you cannot possibly explain what we see from the Sheen-Plum exchanges. Sheen's text messages, plural, reveal marked enthusiasm on his part for whatever the topic was, an urgency to discussing it, and a commitment to doing so only under conditions of secrecy. Now, as far as the disclosure shows, there were no documents immediately following this call from within Orange or EE or Vodafone referring to Mr. Sheen having made initial contact in relation to a supposed possible joint acquisition. Not a word within either undertaking referring to the fact that contact had been initiated to discuss such joint acquisition. Mr. Sheen, despite all his enthusiasm, seemingly dropped the idea dead on the 4th of April without giving rise to any document that made its way into disclosure revealing that he had tested the waters with Hum, and without ever mentioning the idea again in any meeting for which we have minutes. Standing back there, the idea that the 5-minute call was about a joint acquisition is no party's case, no witness's evidence, and has nothing to be commended. In our submission, if the evidence that the judge did not refer to and apparently did not take into consideration had been weighed in the balance, it's likely that he would have reached a very different conclusion. But as I've said, that isn't the test. We only have to show that it could have made a difference, and that hurdle is cleared by a wide margin. Moreover, if the judge was arguably wrong, as we say he was, to conclude that the topic was a joint venture acquisition rather than a joint exit, this would have required a root and branch reassessment of other evidence, which Phones for You submitted was further evidence of collusion between these MNOs, such as, by way of example only, EE's expectation that Vodafone was about to pull out of Phones for You, which I've dealt with under ground 3. Next, modelling assumptions. Moving on a few weeks from April to May, in early May 2014, specifically the 5th of May, EE's financial modelling of what would happen if it exited from Phones for You became notably more optimistic. Understanding why this happened was central to Phones for You's case. And as we will see, this point requires a little unpacking, and we'd respectfully suggest that it's not perhaps surprising that the judge appears to have failed to properly recall or address the relevant evidence. Of course, surprising or not, that doesn't make it any less problematic. Phones for You's case, which included reliance on EE's written and oral evidence, was that the change in the modelling assumptions on the 5th of May was the result of instructions to the modelling team from Messrs Milsom and Alera, who were party to collusively obtained information about Vodafone's plans. I've already mentioned ground 3, and in that context I mentioned earlier today some of the evidence which shows these executives moving from the view that a Phones for You exit was unacceptably risky. And you saw that in the minutes of the board meeting of the 20th of March. They could pull in in the event that EE exited, they could pull in other MVNOs and fill the space. But by the time we get to the middle of May, in meetings, they're expressing the view that if there was a joint exit between EE and Vodafone, and Phones for You would start. Now, the allegation was, armed with collusively obtained information, Milsom and Alera asked the modelling team to make different assumptions about what would happen to Phones for You following an exit by EE. The judge rejected that case, as we'll see in his judgment, because he considered that the sharp change in EE's modelling was instead explained by a piece of analysis which EE did around this time on phones for use cash flow in the event of an exit. But in reaching that conclusion and our submission, he disregarded Mr. Ayer's written and oral evidence, and he was the one who had responsibility for the financial modelling. Fortunately, I do not have to take the court to any of the modelling itself, but I should introduce two terms of art which are important to understanding the dramatic change in modelling. The first term of art is absorption rate. This is the rate expressed as a percentage of EE's volume of phones for you that it would retain following an exit. So, for example, an absorption rate of 25% for upgrades implies that if EE exited phones for you, it would lose 75% of the upgrade business which it would have obtained through phones for you. The reasons for a low absorption rate are obvious. If a customer looking for an upgrade to their current mobile phone contract goes into a phones for you store, finds their desired handset, and let's be clear, handsets were a very important, attractive feature in this market, as they still are today, but no connection to an EE network, the customer would likely not purchase the handset with would likely purchase a handset with a connection to another MNO. Now, broadly similar analysis applies to new connections. A customer that comes into a phones for you store looking for a new connection is unlikely to decide against making a purchase simply because they'd ideally prefer to be on EE as opposed to Vodafone or T-Mobile or Life Mobile. Some customers would, but most would not. And that is because, as the MNOs themselves recognised, phones for use customers were network agnostic.
If somebody wanted to have an EE, be on the EE network, would have gone into an EE shop.
Yeah.
Just as those of us who were on Vodafone went into Vodafone shops when there used to be Vodafone shops.
Yeah.
So I should probably have revealed that I had a probably half the room does.
The network agnosticism, and particularly with phones for you's customer base was predominantly youthful, as the judge says in his judgment. They had a strong intro with individuals who are rather younger than myself, and like my adult kids, they like the shiny handsets, and they don't care whether the shiny handset comes with a connection to Vodafone or EE or anyone else.
Well, I think when there were phone shops on in and around Fleet Street, I don't recollect there being a phones for you one, presumably, because all the people around here are old fuddy-duddies. There certainly was a car phone warehouse. Yes, I remember that. It's off of Sergeant Sin.
But I can't assist the court as to whether Fleet Street had phones for you. But the upshot of this analysis, the absorption rate, is that if phones for you remained on the market and did not exit following did not leave the market following an EE exit, EE would most likely see most of its would-be phones for you customers buying connection with somebody else from its competitors. And that anticipated loss of volume was fundamentally at the basis of the prisoner's dilemma that they faced. Now, so it's not therefore surprising when in April, I think it was, that modelling, EE modelled what might happen in the event of an exit from phones for you. It assumed low absorption rates. If we...
Sorry, you said there were two expressions you had.
I'm coming to that. I don't want to disappoint your ladyship. Can I, before we get to that interesting term, can we look at supplemental bundle 1, tab 4, page 101. Supplemental bundle 1, tab 4. Mr. Ayer's witness statement. think is it?
Which paragraph?
Page 101 to 102.
Paragraph 48.
Paragraph, yes, paragraph 49.
Okay.
As at 4th April, EE's modelling in relation to a scenario of negotiating improved terms of car phone and pulling out of phones to you indicated this would reduce EE's EBITDA. And then you see in little a, E would absorb 25% of acquisition volumes, which is otherwise obtained by phones for you. Sorry? And over the page at 102, 25% of the upgrade volumes, which is otherwise obtained by phones for you. And then you'll see in C, the term which I'm coming on to explain to your ladyship, handset cost efficiencies. So there are two aspects. Absorption rate, if we exit, it's likely we won't be able to retain a large majority of customers who we would have otherwise obtained through phones for you.
Yeah.
The second term of art to have in mind is this handset cost efficiency. That, I'm told, by those who know better, is more of a euphemism than a term of art, but let's not quibble about whether it's a euphemism or a term of art. The so-called efficiency featured in modelling from May onwards, because if phones for you were to exit the market, EE would benefit from weaker price competition and could expect to make more money on each connection that it sold. Mr. Ayer's evidence, I'm reminded that handset efficiency is effectively a price increase. So if you're not having to deal with these price increase.
Yeah,
so if you're not having to deal with these troublesome,
really pricing their ability to charge more for the handset.
That's it. If you're not having to deal with these troublesome competition from phones for you, you're going to be able to charge more. So that's a handset cost efficiency. Now, originally, EE did not include handset cost efficiency when it was modelling simply its own exit from phones for you.
Right.
But when we get to the end of that month, we'll start to see that handset cost efficiencies feature. And it's at this stage, that we start to need to focus on dates. On the 28th and 29th of April, Mr. Ayer had meetings with Mr. Alera and Mr. Nilsson and discussed his modelling with them. And if we could look at paragraph 58A on 106 of the document we have currently open on the screen. Now, so perhaps if we start at 57, sorry.
Yeah.
On the 5th of May, I sent Alera some draft modelling in relation to 7 scenarios. And scenario, well, there are 7 scenarios that you see there. In 58, it says, by that point, E's modelling assumed, amongst other things, that in scenario 1, signing in a large car phone contract and pulling out of phones for you, E would absorb, through car phone alone, 70% of the acquisition volumes it would otherwise have obtained via phones through you, and through a combination of car phone and E's existing direct channels, 60% of the upgrade volumes which it would otherwise have obtained. Now that's a dramatic increase in the absorption ratio from 25%, almost tripling it to 70%. You'll see, and doubling it at least doubling it in relation to the upgrade volumes. And in A1, Mr. Eyre says this: I can't recall precisely how I came to use these absorption assumptions in the draft modelling for scenario 1 as at 5th May. However, I can see from an email I sent to Ms. Talbot, Ms. Shah and Mr. Sahota that earlier that day, on the 28th, I had discussed with Mr. Alera and Mr. Milson a range of absorption rates in relation to the scenario. And so what we see is that in his 5th of May modelling, Mr. Eyre assumes very much more optimistic absorption rates for new connections and upgrades. And for the first time, we see that this included an assumption of handset efficiencies. And we see that if we turn over to page 107, at the bottom of the page, under C, EE would benefit from handset cost efficiencies of £34 million per annum. Now, if we look over to 108, and under Roman 5, he says, I cannot now recall this. The inclusion in the draft modelling for scenario 1, handset cost efficiencies of 34 million per annum, might have reflected a provisional view following discussions with Alera and Milson that phones for you were likely to represent a significantly reduced presence in the market following a withdrawal by EE, because EE could not otherwise, in my view, have realised handset cost efficiencies of this scale. And I think we also need to go back to the April modelling to join the dots.
So is that saying, in layman's terms, phones for you share of the market will drop to a very considerable extent? Otherwise, you can't explain why EE would be making so much money out of the handsets.
Yes. Yes. Okay. And the proposition is that either phones for you is no longer in the market, or it is a very much reduced presence in the market. Now, I was going to show the court, join the dots on that, in paragraph 51 of Mr. Eyre's evidence, which is on page 102 of the bundle. Now, subparagraph A, EE internally were thinking, and the court will recollect that there was an enthusiasm.
Sorry, where are we?
Forgive me, my lord, 51 on 102. E's internal thinking continued to evolve. Now, one of the scenarios which E internally was looking at was A, negotiating improved terms with Carphone, whilst also acquiring phones for you with Vodafone to absorb part of Phone for You's real estate. Okay, so that means that effectively Phones for You is out of the market. And what we see in subparagraph C, that in that scenario where Phones for You is taken out as a competitor, this time jointly by Phones for You and Vodafone, E would benefit from handset cost efficiencies of 34 million per annum.
We go down.
Because Phones for You's exit from the market would lead to less aggressive discounting of handsets.
Yeah.
Okay. So that's
back in April.
That is.
9th of April.
That's back in April.
But the modelling with the handset efficiencies only comes in nearly a month later.
Yes. But yes, your Lordship's right. This is modelling for a potential acquisition. But we're not talking about a potential acquisition when we get to the 5th of May. Right. The handset cost efficiencies move across from not an acquisition, but an exit. So, where you've got a scenario where Phones for You is out of the market, i.e. because it's been taken out by an acquisition by Vodafone and Phones for You, you get handset cost efficiencies. But lo and behold, when we get to the 5th of May, the assumption which was being made that you can include handset cost efficiencies, as Mr. Eyre indicates in his evidence on the 5th of May, is for the same or similar reason that Phones for You is no longer a competitive pressure in the market, which allows EE to benefit from these handset cost efficiencies.
Which is why the figure for the handset cost efficiency is the same.
Exactly. Exactly. Now, can I then show the court how the learned judge dealt with this? Requires the court to look at paragraphs 520 to 521 of the judge's judgment on page 408. Sorry? Court bundle 408. 520, 521. Now, there's a problem with this analysis in that it seems to be the learned judge's approach to two features. Eyre wasn't prompted by Milsom and Alera to start changing the assumptions. That was speculation on Eyre's part, says the judge. And two, because there was a cash flow analysis on the 8th of May, and it was that which led to Eyre to revise his approach. But what the judge did not bear in mind is Mr. Eyre's evidence, as I've shown the court, that his assumption on the 5th of May involved handset cost efficiencies, which was premised on Phones for You not being in the market. The same figure, as my Lord the Chancellor has identified, as was in the assumptions in April, which involved a joint acquisition of Phones for You and taking it out of the market. So the bottom line of this is the learned judge was wrong to suggest and wrong to ignore the evidence given by the individual who prepared the modelling as to what underlay that modelling. It wasn't a question of speculating about who told him what. It's a question about analysing what underlay the assumptions in the model. And that's not explained and can't be dismissed on the basis that, oh, well, there was a cash flow analysis on the 8th of May in circumstances where one can see that already at the 5th of May, the assumptions were there. So it's not a question of the witness's faulty recollection of the sequence of events, but the sales and finance director interpreting his modelling and by reviewing the financial assumptions, he was able to identify and did identify to the court in that paragraph of the judgment of his witness statement I showed you what the underlying factual scenario was, i.e. Phones for You no longer being on the market.
So your point here is that the judge has just completely overlooked the detailed evidence in chief.
Yes. Yeah, absolutely.
So it wasn't necessary to cross-examine him about this because he wasn't.
No,
it wasn't.
No, it wasn't necessary.
The issue.
And I'm going to make clear that it was not part of our case that Mr. Eyre was brought within the tent of collusion.
No, sure.
He was carrying out modelling on instructions from his superiors. Now, obviously, when he carried out that modelling, he would be responsible for the individual decisions that you put into whichever box. But the important point was that when we say, well, how is it when you compare what happened in early April to your assumptions, 34 million hand-cost set efficiency of phones for use no longer in the market. There we are. We see in 5th of May, handset cost efficiencies, phones for use no longer in the market. How's that? And the answer is because he had a discussion with Mr. Nilsson and Mr. Alera. Now, so Ayer confirms in oral evidence that he's been able to infer from looking back at his modelling that it was the start of May, there was an underlying assumption that phones for you would materially exit the market. And can we just look at that? Core supplemental bundle, tab 50, core supplemental bundle, tab, yes, page 127, lines 12 to 17. Internal
which page?
Internal 39. Mr. Draper took the burden of this exciting modelling, and he, at line 12, ultimately, as you say in your witness statement, from looking at the modelling, what you're able to infer now, looking back, is that you started to assume in the modelling that phones for you would exit the market. That's right, isn't it? Materially exit the market, yes. Now, the state of evidence at the close of the trial was accurately recorded by EE in its closing submissions.
Sorry, that is Ayer's cross-examination.
Forgive me, my lady,
Yeah.
I should have said that. Yes, it is. Now, at the end of trial, EE correctly and accurately recorded where we were on this, and if we look at core supplemental bundle, tab 9, page 44, paragraph 72. Yes. And EE submit this at trial. The following day, Monday the 5th, Mr. Ayer circulated modelling for 7 scenarios. This, for the first time, suggested exiting phones for you and entering into an enlarged car phone deal. Consistently with the scenarios, this modelling reflected an absorption rate of 70%. Mr. Ayer explains that this modelling assumes an absorption rate consistent with phones for you having exited the market, albeit that this position was not yet strongly held or particularly considered. So, notwithstanding that, you see what the judge says, paragraph 522 of the judgment, core bundle 1, page 409. And the judge, having misunderstood the evidence and placing the change on the basis of the cash flow wrongly, he goes on to say a number of things in paragraph 522, none of which, in our submission, detracts from the proposition that, one, there had been a change by the 5th of May, and two, that was as a result of communications between Alera and Nilsson and Ayer. Yeah. I mean, I see the time now.
Is that a convenient moment to stop?
It is a convenient moment. I am making good progress and we'll finish on time, obviously.
Good. Right, well, I think we said 10:30 tomorrow morning. Just check my diary. I think that's what
You
we
did.
said. Well, I think we might sit till 5 o'clock tomorrow. I can't remember whether we said we'd sit till 5 tomorrow. So anyway, we can check that tomorrow. But
Yes, I think that's
we sit at 10:30 and we'll take a break at about 11:45, something.
very good.
Be a normal. All right,